Good morning. And today we're this hearing is being broadcast live. So we're really excited, and the neighbor islanders are going to be able to web stream in and watch it. So this will be a statewide hearing. So I want to welcome everyone across the state that's involved and everybody here today in the room that took out their time to come. We have a lot of items on the agenda, but we're starting a little early today because we do have a lot on the agenda. And it's a joint hearing between the Committees on Water and Land and Committees on Ocean, Marine Resources, and Hawaiian Affairs. I'm Chair Cindy Evans, head of the Committee on Water and Land, and to my right is Representative Hanu Hanu, who's the chair of the Committee on Ocean, Marine Resources. 797, which is relating to coastal zone management. And first we have Nancy Davlantis. In opposition, Jesse Suki. In support.
Good morning, Madam Chair and members of the committee. My name is Jesse Suki. I'm the director of the State Office of Planning. This bill was prepared and drafted by my office. We are the lead agency for the Coastal Zone Management Act in the state of Hawaii, the purpose of which is to provide for the effective management, beneficial use, protection, and development of the coastal zone, which includes the whole state and out into the ocean. But what we're looking at here in particular is one of the tools that we use for managing the coastal zone, and that would be the Special Management Area Permit. So it's the Special Management Area that's developed by counties, which is from the shoreline, Mauka, to usually the first highway, but it can be further inland. And currently the way the Special Management Area Permit works is that counties are responsible for assessing the permit for any development in the special management area, and then depending on whether it's over or under $500,000, the Planning Commission on the neighbor islands or the City Council here in Honolulu gets a final approval of the permit. What we were asked to do in the last legislative session by some of the legislators and the governor was to look at how we might streamline statewide some of the permits that different and various agencies have. So since our office is the lead agency for this particular permit, we looked at the SMA permit. And what we developed working with partners, agencies, federal, county, and people from the community was a permitting process that would allow a streamlined permitting that accomplishes the objective purpose that I mentioned early on for state projects on state land. So it's very narrow, and I hope it stays that way if this passes. It's very narrow, state projects on state land. And basically the way the process works is that if the agency is required to get a CZM federal consistency review, and a federal consistency review is a review that our office does for federal projects that may have a reasonable impact on coastal resources. So if they have that, then they don't need an SMA because it's duplicative. If they don't have a CZM federal review, then the next question they'd ask is, do we want to go through the process that's already in place, or do we want to do a self-certification process? So the way the self-certification process would work is that the agency who has a state project on state land would evaluate the criteria and requirements under the Coastal Zone Management Permitting rubric, and they would put out that review to the public so that the public has an opportunity to comment. Any comments that they have, they would need to address, and our office would have an opportunity to look at it as the lead agency, consultation, and ultimately the agency would sign off on it. And the difference between that streamlined permit and the county review is that the county wouldn't have the final approval. We don't think that that's such a big issue, because a lot of permitting in the state for counties are preempted by the state anyway. This is one of the very few permitting regimes that was set up by the state in the 70s that put the responsibility for reviewing state actions with the counties. So we have had some concerns from the counties about this rubric and this proposal. You know, we've heard that you know, they like having that decision making on the ground for what happens in the county. So maybe we can work through that. But we believe that based on the request to look for a streamlining effort, this is as good as it can get. We have a regime that will help us achieve the goals and objectives of the CZM policy. It has public comment input. It has consultation with our office. For those reasons, we support the bill.
Okay. Thank you.
Thank you.
Mary Alice Evans.
Good morning, representatives. DBED stands on its testimony in support of this administration bill. Thank you.
Thank you. Department of Transportation.
The Department of Transportation stands to support this administrative commission.
Thank you. Hawaii Thousand Friends. In opposition, William Island, DLNR.
The department stands in support of this bill.
Anyone else wish to testify?
Good morning. Chairs, members of the committee, my name is Robert Harris. I'm the director of the Sierra Club Hawaii chapter. We're in strong opposition to this measure. It's a really overused phrase, and I apologize for trotting it out again, but this is sort of an example where you're putting the fox in charge of the hen house. While this obviously does streamline state approvals, there's a number of problems with the overall concept. For example, it requires the Office of Planning to consider public comments, but there's no consequences for ignoring them. There's no obligation to actually have to respond to them. There's no obligation to have a public hearing. For example, if there's a neighbor hearing, if there's a neighbor island, there's an obligation to have a hearing in that area where currently the planning department or the county would have that obligation. There's no enforcement capacity, administrative process for violations, or a clear ability to levy fines. It places state projects on a unique course, different than private projects, which does raise questions about sort of the way the process overall is being run. It doesn't create an obligation to actually be able to enforce conditions. So, for example, the state promises to do best management practices to reduce soil runoff or everything. There's no really way to enforce those conditions as a part of the process that normally you would have in an SMA. And quite frankly, the experience with state agencies has been some of the worst. Normally, if you have a private developers have some obligation to have community buy-in. They don't want to be a bad player in the community. Unfortunately, state agencies, I don't want to say that they don't think about those things, but they usually come in sort of with a single-track mission. You know, we're here to build a highway, and that's really all we're here for. It isn't necessarily the ability to have to interact with the community as much. And let me give you one example. On Maui, where the county had specifically wanted to rebuild a highway along through to Lahaina. They really wanted to build it further up Mauka. They didn't want to destroy the beach. They'd actually purchased the land. They'd done an EIS to do this. Unfortunately, the state used the governor's power to declare emergency declaration, went ahead and built a seawall along the beach, absolutely destroyed the beach. It's gone. The community will never be able to see that beach again. And we're actually having massive erosion problems. They're going into the coral reef and destroying the coral. Now, if you'd had a public hearing process, if you'd actually gone through the SMA process, I'm sure the county would have registered strong objections and said, no, you know, we want you to move this up further Mauka. There's no real hurdle to doing that. Finally, I would register, and this is, I admit, maybe a little bit of a whiny objection, but they spent a year developing this bill, and at no point did they try to reach out to the community, or in this case, the largest environmental organization in the state of Hawaii, and try and discuss this. Dave Rainey, one of my members, actually is the person in the 1970s that helped pass the Coastal Zone Management Act and spent years doing it. I mean, we have experience. I think we would have been willing to work with the state. The fact that they never picked up the phone is, in of itself, I think, a little objectionable here. Thank you for the opportunity to testify.
Can you submit written testimony
Absolutely.
for the record? All right.
Absolutely.
Thank you. We appreciate it. Thank you. Indigenous Consultants, LLC. Okay, support. Marine and Coastal Zone Advocacy Council. And support. OHA. offered comments. Anyone else wish to testify? No? Okay. Members, any questions? Yes, Representative Thielen.
Thank you. William, do you mind coming up? And Robert, could you come back up? Every time I hear, let's go streamline the process, my antenna come up, and I think this is probably not going to be a good situation. And I think back to your days sitting across the table as an advocate for the environment and how many times you would challenge those kinds of actions. I'm asking if the purpose was to find a way to do things better, not just streamline, because I don't think streamline improves things necessarily. But if were a way to to do things better, why didn't you reach out to the environmental community? I don't mean you personally, but I mean the department. Why not reach out to the environmental community, sit down at a table and say, does this even make sense to go ahead? And work through that.
I guess
and now put on your activist hat from those days that I knew you, William.
I'll do that actually in testimony on a bill later on.
Okay.
But this is the second attempt. Last year there was an attempt to do the very same thing, and so my friend here opposed the bill at that point, and we had many discussions, and we actually had one interesting conversation on a PBS show, and so why we didn't reach out to this group from the Department of and the Natural Resources standpoint, basically because I felt, and this is actually a state planning bill, so I don't know why. I can't speak for Jesse. You're going to have to ask Jesse.
State planning makes me very nervous too, because state planning that wants to avoid streamline the process is just like bringing us PLDC too.
Okay, well, I don't think it wasn't an administration bill, so I got to point that out for the record. If there is an opportunity, as my colleague here presents to us, I think we certainly can have some discussions and maybe take a look at some amendments to go forward with this bill. One of the real life situations that the department is in right now is we have a basic repaving of a raceway facility on the island of Kauai, and the tiniest sliver of a corner is in the SMA situation. So we've been held up by the county of Kauai for about a year now on this tiny sliver of a corner that's in the SMA, which is basically repaving the existing racetrack. And so a bill like this, I think, helps us deal with this situation where the county, for some reason, I think is holding things up for what is basically a repair and maintenance job, and the tiniest sliver of the corner is in the SMA, and we're having to go through all of these extra hoops for basically a repaving job. So I think that's the justification for why the department is interested in, as you put it, streamlining, as I would call sort of right sizing for the project at hand.
That's going to be an equally dangerous word, William. Well,
perhaps maybe if I could just echo on
Sure.
that. I mean, that clearly demonstrates the need for conversations, because repair and maintenance is clearly exempted from the SMA process. So if it is truly a project where all you're doing is repaving, this is an example where you don't need the county permission to move forward.
That's not according to the county. So
well, but again, this is an opportunity for a dialogue conversation. And there's examples where on Maui, where the DLNR has actually done memorandums of understanding with the county to really talk about how these types of projects move forward, and having the dialogue about where delays are occurring and why delays are occurring and trying to resolve them, rather than simply saying throw the process aside and say we want to create something new where we're able to just get around it, is really the preferable way to do it.
And then that makes sense, Robert, because I look at this as a dangerous bill because it sets a precedent, and maybe it's a sliver today, tomorrow it could be something much more major. But what Robert is suggesting, taking the need for this kind of a bill and putting that into a resolution directed possibly to the counties and maybe the county of Kauai to say, come to the table and let's find a way to do these repair and maintenance projects where there won't be major damage. But I'm not ready to put a PLDC2 through. And I think it's just dangerous to do that. And I think the word streamlining, if that's coming from the fifth floor, I think we ought to ask the fifth floor to rethink that. Because the public made it real clear with the PLDC outcry that streamlining is not what we want. Protection of our resources, our natural resources, our state lands is what we want. And I think what Robert is suggesting makes a great deal of sense. And sorry as I'm lecturing, but I am tired of the departments coming, and I'm sorry, William, because you would have been opposing this in your former life. But I'm tired of the departments coming and saying.
Thank you. So to keep the committee going, I just want everybody to know that the chair and I have conferred. We will be deferring this bill, so we won't be voting it out. But Representative Kaufman, question, please.
Yeah, thank you, Chair. Mr. Harris.
Yes.
The coastal zone management laws, you're implying that they're not adequate?
I'm not sure if that's what I'm saying. Again, right now, the way the law was passed in the 1970s is that the counties had strong concern. They really wanted to make sure that the authority and responsibility was delegated to the counties, so they had the ability to authorize it.
Not authority, but the federal coastal zone management laws are inadequate to take care of our state coastal areas. That's what I'm hearing you say. And we need additional.
The Federal Coastal Zone Management Act delegates everything to the state to decide how to move forward, and they require that you've complied with what the state has decided. So here, if you've gone through the state process, the federal government says that's okay. So if you make a very weak state process, the federal government will say, okay. So again, here, this is a situation where the state gets to decide whether or not you want to protect the special coastal areas that are unique and special to Hawaii. And this was a decision made, again, in the 1970s, how this process worked. And it's a process that, generally speaking, has worked very well.
And the Sierra Club helped put this together, the coastal zone management.
This was, yes, years of legislation, discussion. A number of stakeholders were involved.
Okay, thank you. Office of Planning, if I may, Chair.
Yes.
Chair.
I think I heard two words from you, the word streamlining, which seems to have gotten some people upset, but also the word that this is to avoid duplication. Which word fits better?
Well, I think they both fit. I think there's a misunderstanding and mischaracterization about what we're trying to accomplish here. Streamlining is not exemptions, and I have never supported exemptions. We're not talking about that here. We're talking about fulfilling the promise of the purpose of the law that was established in the 70s, but using a different system to get to that same point. The system hasn't been working specifically for some state projects where there's been disputes on the ground level between counties and the state about how they evaluate and process these permits. In many places, the state preempts, but we're not asking for an exemption here. All we're saying is that there's another process we can follow. And also, while we looked at it and looked at streamlining about how we can do it better, we realized that there was some duplication. For example, with the CZM federal consistencies reviews that our office does, is the same thing that an SMA permit does, more or less. We look at the same criteria under 205A-2, which are the state policies for CZM, but there is no contested case, but there is a public comment period. Much like the EIS law, there's no contested case, there's a public comment period. So what we're looking here for the streamlining effort is that there'll be a public comment period, but not a contested case. I'm not sure that the people who opposed the bill actually read it. There is a requirement in there that the agency that's responsible for making this review shall provide its responses to its comments to the community. So the community will have an opportunity to look at those comments. And at the end of the day, the big hammer is that people can sue if they don't like the way that it's handled. And we took specific cautions because we are concerned about the public having an opportunity to have an input in this process still. We're not taking them out. So they'll be able, under the statute, if an agency chooses to follow this process, they're required to make all of this open and available to the public, not just under the Chapter 91 or 92 request, but through this process, it'll be available.
Thank you.
Okay. One moment. Yeah, Representative Lowen.
So I'll ask you this, Jesse, but if anyone else has an answer, you can jump up here. With SMA, there's an existing exemption process for minor actions already?
Yes.
And same for Chapter 343?
Yes.
So do you think that agencies claim exemptions as they should be claiming them to promote efficiency and not sort of going through the process when actually they don't need to, and there is an existing process where they could claim an exemption already?
So let's be clear. We're talking about exemptions within the rubric of an environmental review process. So we're not talking about wholesale exemptions, which I don't
Yes,
like.
like exactly.
Right. So
yeah.
you're talking about within the process. So the type of exemptions that are in the SMA, for example, are for impacts that the legislature has determined are minor and not going to have any
Yes.
repairs
Right,
to
projects
existing
that should.
structures.
So what I'm
Right.
saying is,
I think I'm not familiar with all of the facts that Mr. Ayala was talking about, but if the exemption list applies, but if there's a cumulative impact notwithstanding the exemption, then the county would require a review through the SMA permit process, so it wouldn't be an exemption anymore. So maybe that's what happened there. The county made an interpretation, I don't know, that maybe the exemption is here, but there's too many impacts, so we're going to have to look at it through an SMA assessment. That could be the case. So
I guess what I'm getting at is, do you ever think there's a case where an agency could claim an exemption, but they choose not to? An exemption meaning like a categorical exemption that's already in the rules, that environmental groups and everyone is okay with. It's already in there. The process could be more efficient if they claim the existing exemptions that are already there, but they choose not to.
Well, I actually think the streamlining process is better than an exemption, because an exemption means you then don't do anything. I'm exempt, I'm going to go build. With this process, there's always going to be a constant consultation and an opportunity for the public to comment. If they choose this process, they could also choose the existing process.
Okay. Thank you. Representative Hawaiian.
I'm sorry, I have to make one last comment. We did coordinate in the MACSAC, the Marine Advocacy Council is an autonomous board in our office that are made up of 2 members from each of every counties from the community, and one of their tasks is to spread the word about these issues to their constituents, and they have. We also coordinate with over 40 different federal, state, county, and community people who are involved in the update of our Ocean Resources Management Plan, who had a look at this and was able to comment. You're not going to make everybody happy with a proposal, but we're trying to meet the objective of making this system more efficient for achieving the purpose of the law, and this is what we came up with through that consultation.
Okay.
Well, I just wanted to add a comment. In your streamlining process, are you also going to be inclusive of the spatial marine plan? Is it inclusive in there? Because this is a federal mandate.
For this particular process, spatial planning is not part of it, but at some point in the future.
And why not?
Yeah, no, at some point in the future, because that's a separate project we're working on. We want to get a better understanding of what's going on in the ocean. So we're seeking opportunities to use spatial planning, which is basically geographic information about where things are happening in the ocean, to have a better understanding when working through the permitting process of knowing what's on the ground. It's always good to have the best available science and best information. So we're looking at receiving funding for working on the project soon. We're actually competing for it with other coastal states, and if we get those monies, then we'll be because we have an Ocean Resources Management Plan update now, something that will add to make that a stronger plan. We've had good support and comments for
But
pursuing.
aren't we the coastal state?
Oh, so that project we're talking about is for state waters. It's for
Right.
Yeah,
It's for state waters, but
Yeah.
being that Hawaii is all surrounded by waters, so wouldn't that have been a priority? That's what I'm saying.
Yeah, it is a priority, but not as part of this this proposal. It's not. It's a separate project that we're working on, which could inform it in the future. But for now, that's not part of it.
Right. And then I heard you. What was that word you had used? Well, I mean, we know we're already in the process of doing the aha moku, right? So those are generational cultural practitioners that know the lands, whether it's from the mountain to the sea. So are they going to be inclusive in your talk stories or your to consult with them?
Absolutely. For example, with the Ocean Resources Management Plan update that we're working on now, which doesn't include a spatial component, which would be, getting geographic information of the oceans and things. But for that planning effort, we went across the state in 2 rounds. Sometimes we had more than one meeting in various communities, and we publicized it to the hilt, and we had all kinds of people show up from the community. On our ORMP, we interface with also OHA and DHHL. And so when the AHA MOCO has their system set up, we consult with DLNR, and the AHA MOCO advises DLNR, so we'll work with them through that mechanism.
Thank you.
Thank you. Members, any other questions? Okay, if not, we're going to recess the joint hearing, and then we're going to adjourn the Committee on Water and Land for House Bill 1249 relating to Hawaii Community Development District. First up, Dennis Onishi, Hawaii County Council. In support, Anthony Ching, Hawaii Community Development Authority.
Good morning, Chair Evans and members. Anthony Ching, Executive Director of the Hawaii Community Development Authority. Our testimony is that we take no position and offer comments. And we also note that given DLNR's testimony in opposition, we certainly defer to our sister agency with respect to matters affecting their administration of state lands. I'm obliged to be a little bit nitpicky. The title might be flawed in that it references Hawaii Community Development District, but nowhere is the district, that particular district, described in the proposal. So you may have a legal issue. I believe to strengthen the clarity of intent, I think on page 2, lines 3 to 6, lines 7 to 11, there's references alternately to board and authority. And for clarity and or lack of a definition page, that might be an issue that should be clarified. With respect to governance structure, I do note that beginning on page 11, section 2 of the proposal, it completely reverses the structure, membership and governance structure that was just established by the last legislature, Act 323, Session Laws 2012. With respect to the, again, impact upon DLNR operations, certainly it's important that DLNR not lose its revenue and assets to do its job. And so, again, we would ask that those consequences be factored into your deliberations. With respect to the capacity and mission of HCDA, we're certainly capable of taking on something as described as our 3 main responsibilities are to wield zoning, to conduct community master planning, follow through with infrastructure projects, and then steward assets. But having said that, without that kind of clarity, there might be some legal consequences unless corrected, as well as negative consequences to the operations of DLNR. Thank you for the opportunity to testify.
Thank you. DLNR.
Thank you, Madam Chairs. The department opposes this bill for several reasons, and one of the main reasons is the financial impact to the department. The current land leases, in terms of revenue to the department, is just under $1 million, and these are on assets that are undervalued. So, in the future, the revenue potential for the department is much more significant than the $1 million, as significant as that $1 million is. With regards to redeveloping in the area, one of the issues is many of the current lessees are at the end of the cycle of their leases. The legislature passed Act 219, Session Laws 2011, which actually authorized the board to extend hotel leases up to another 55 years under certain conditions, and those conditions meant significant investment in the area. To date, we've only worked with one lessee who has come forward. We stand ready to work with any other of the lessees that wish to come forward with proposals for serious investment into their hotel properties or resort properties. So we have a mechanism on the books right now to deal with the issue of lessees coming to the end of their lease and wanting and being afraid to invest more money. So the legislature has already passed Act 2119, which can help us move forward with any serious applicants that want to come forward to redevelop this area. So with those two comments, again, I remind the committees that we strongly oppose this bill because of the serious consequences that it has to the department's operation.
Okay. Thank you. Anyone else wish to testify? Not members, any questions? Yeah, Representative Kaufman.
Thank you, Chair. Mr. Ayala, what percentage of the land under your control would you classify as, I would call it urban or commercial type property versus ag land? And
I'm going to ask Administrator Russell Suji to come up and provide you with that information. He knows it much better than I do.
And chairs, committees, Russell Suji for the Land Division. I'm sorry, I don't have an exact percentage, but I can tell you as far as in the urban area or in the resort industrial type areas, industrial, commercial, it's a very, very minute percentage of the total acreage. We have 1.3 million acres of state lands under the Board of Land and Natural Resources. A lot of them executive ordered out or leased out to, executive ordered out to the other agencies or private leases. But I can assure you, as far as the urban or resort, very, very limited, very minute. So Banyan Drive is one of the few, as far as resorts from the top of my head, resort areas, Banyan, and one small little hotel in Maui.
Okay. Because I understand the implications of the rent, but I would think most people would think of the LNR handling the rural lands, and when we get into areas similar to Kakako and things like that, where there's a need to have some kind of a master plan and actually proactively work towards improving it, I do see a conflict. Do you have anybody in DLNR that does that kind of work for this kind of property?
In my division, in the land division, we do have a small group that, because prior to that, the board, because of the vast amount of lands, and yes, a lot of lands under our jurisdiction are obviously the ocean, the mountains, a lot of rural areas. But in order to support the programs at DLNR for protection of natural resources, I think the board recognized that there has to be at least a portion of those lands where appropriate for income production to support the department, and that's what we try to do. And I think we're, Chair can comment more, but I think our division is rather successful at helping support the other divisions as we laid out in our testimony.
And that group is different than the PLDC?
Yes. Okay. Yes, we have to follow all entitlement processes. Yes.
It's a process that was put in place probably about 4 or 5 years ago, recognizing that the general funds that was coming to the department was declining, and therefore we needed to utilize the lands that were under our control in more efficient manners to raise revenue. So it's the constant challenge for the department, right? Protect, but make some revenue so that you can protect.
Thank you.
Thank you.
Thank you, Chair.
Chair Ayala and Anthony Ching. Thank you, Mr. Suji. I believe with the HCDA, don't you have a process like an advisory council, a group that supports what's going on in the authorities area?
I think we've established stakeholder groups in particular areas where we have clusters. For instance, we administer Kewalo Basin Harbor. In that particular case, we've established a across the spectrum advisory group. There are other advisory groups for the Mauka area and ad hoc groups that we also will convene.
Okay, because I'm seeing some value in this, but not as the way it's written. And one of the things being is it is a resort area. It has an amazing amount of potential. It's just fabulous. It is an area that needs to reinvent itself. I can see DLNR still being the landowner, but to help them in a system, I can assist them. I can see why there may be they're calling it a community development board, but more of a community development advisory board, in that I think we need to bring more capacity to the department to help them address the issue. Because your staff, I mean, I have to believe with all the cuts and everything that we've done over the years, for your staff to actually focus on this one area, to come up with a master plan, a business plan, reach into the community, talk to the the county council, the mayor, and all the things to do a kind of a resort node type of development is a lot of staff time. So I'm wondering how we can convert this more into, instead of a board going in and doing the policy making, you have a group that's in there really driving us, getting the business plan, master plan, and what we need done. And I think they do HCDA. You have that assistant, don't you, from stakeholders? That's why I'm asking the question. There's got to be something we can do, because right now people I think they're asking us to help find a way to help this move along.
If I could answer that first. With regards to the administration's Harbors and Parks Development Authority that we have before you, there is a provision in there to access the expertise and the staff of HCDA. So the department would be certainly willing to work with HCDA and bring their expertise and bring their staff in and assist our staff in this development that everyone agrees has to occur in Hilo. So we would be open to that possibility. I'm going to put words in his mouth. He can say now what he thinks.
Well, Chair Evans, I'm again acutely aware of the negative impact that loss of revenues would do to the Department of Land and Natural Resources. So on that first answer, and I haven't had a chance to discuss it with Director Ayla, but the logical conclusion would be do not transfer ownership of the lands currently titled to DLNR to HCDA as this bill provides. Then should a structure such as you describe or the legislature establishes, that would give us the responsibility, no profit, the responsibility to develop those master plans, to follow through with infrastructure improvement projects as appropriated by the legislature, and then affect the changes, but it doesn't affect the finances. Again, I didn't consult, but I hope that's appropriate from DLNR's standpoint, but if we take no money and the revenue remains with DLNR, the benefit can accrue.
Okay, all right, thank you, appreciate it. Members, any other questions, comments? Okay, thank you, members. We're going to adjourn, or recess, excuse me. We're going to recess the Committee on Water, Land, and then we're going to reconvene the joint committees, Water, Land, Ocean, Marine Resources, and Hawaiian Affairs on House Bill 509. Dr. Kenneth Conklin. Opposed, Charlie Ota. Opposed, Jesse Suki.
Madam Chair, Jesse Suki, Director of Office of Planning. As the lead agency for CZM, we just provide comments. And the comment I just point out in our testimony, there are others, that if the commission is created, it looks like they'll be responsible as a lead agency like counties are for issuing special management area permits. So they'll need the capacity to assess and evaluate special management area permit applications, and then if the streamlining thing is not passed for state projects on state lands, they'll have to be able to do a contested case hearing and follow through with that process through usually a board.
Okay.
Thank you.
Thank you very much. William Prescott. Oppose. Office of Hawaiian Affairs. Okay, support, David Hankin, Earth Justice. Support, Mark Mahoney. Oppose, Charlie, let's see, Calvert Young, Department of Budget and Finance. Oppose, Momi Kamahele. Support, DLNR.
Madam Chair, Department of Land and Natural Resources stands in support of this measure.
Ele Male Ehia Quitevis in support. Frederick Dodge. Support. Karen Young. Support. Life of the Land. Support. Intent.
Oh, right here.
My other hat. Good morning. I'm Kat Brady, testifying on behalf of Life of the Land. We support the intent. One of our problems with the bill is including the military on the commission. We know that on the Burial Council, the thing that's really jammed up the meetings and made it unworkable is the fact that developers are on the committee. And we think it's kind of inappropriate, since they're going to be negotiating with the military about leaving Makua, that they sit on both sides. So we would support the bill if the military positions, the 2 military positions on the commission, were deleted. Mahalo.
Thank you. Kim Kahule Bernie. In support.
In support.
Oh, hi.
Hi, Representative Evans, Hano, and greetings from Ko'olawe to Representative Thielen and to you all. I'm with the Protect Ko'olawe Ohana, and I'm glad that you have the testimony there. And I'm in support of House Bill 509 for also with reservation for the same reason that Kat Brady brought up. There are a couple of them. First of all, what I like about the bill is that, like Chapter 6K, which creates the reserve for Kaho'olawe, that it acknowledges religious and cultural practices in Makua Valley. I like the fact that it includes lineal descendants and members of the Wai'anae community. I'm a lineal descendant of the ranching families of Kaho'olawe, and so I appreciate that there's that inclusion there. There are a couple of other things that I like about the bill. I think that it's inappropriate. In Section 7 of House Bill 509, it talks about the transfer of the island, and it refers to the fact that that this commission will enter into negotiations with the Army to when the lease is up. And for the same reason presented already, it doesn't seem appropriate that the Army should both sit on the commission and be involved in negotiations. So I think that that needs to be separated. In addition, and I haven't talked to Mike Naho'opi'i, he's here too from the Kirk. So I haven't really talked to him, but I know that there are issues with the Rehabilitation Trust Fund. And there's a point in this House bill as well that that describes the trust fund in a little bit of detail, but it doesn't provide any the ability to receive private donations, grants, and donations from individuals, philanthropic and corporate organizations. And I think that that has been a little bit of an issue for I've observed as an outsider, that's been an issue for the Kaho'olawe Island Reserve Commission. So I think that those 2 points might be amended. This body may look at amending those 2 points in House bill. Otherwise, knowing how the community developed the Kaho'olawe Island Reserve Commission. Oh, one more thing, and I'm so sorry. I understand. I know that you know that this was modeled pretty much after the Kirk, the Kaho'olawe Island Reserve, but one thing, once the bombing of Kaho'olawe stopped in 1990, then a congressional commission was formed to study the island and to determine what should be its disposition. At that point, after 3 years of research, community consultation on all islands going into the communities, then it was determined that it should be returned to the people of Hawaii, and then it was decided, should it go to the National Park Service, should it be under OHA, should it be under DLNR, and there were other entities, and then there were some decisions. So it's pretty awesome that some of those steps can be skipped through, that the lessons of Kaho'olawe can be learned and applied to Makua Valley. But I would ask, and it's a question because I truly am not entirely familiar, I would ask, has the process of community input, has that process taken place with the people of Makua, with Huio Malama Makua and with Malama Makua? Has there been adequate community input into this disposition of this, or have we completely skipped over that and just come right to the bill modeled after the Kaho'olawe Island Reserve Commission? So those are my three mana'os. Mahalo for the opportunity to testify and to compare this reserve proposed for Makua to that of Kaho'olawe. Mahalo.
Please stay, because I'm going to have questions for you at the end.
Thank you.
Thank you. Okay. We have a testifier. I'm sorry. He hand wrote his signature, and I can't read it. It looks like Will J. I'm sorry. But anyway, I want you to know it's another testimony in support. Oh, okay. Is that your signature? You wrote that and then you typed it? Because I was going to say William Island next. That's you both. Okay, now I know what your signature looks like.
So officially, I am an employee of the state of Hawaii, but the testimony that I'm about to give is that of an individual. It's been a long time since I've had to do that, right, guys? and I first want to address Representative Thiemens. Yes, but knowing what I know now about processes and sitting on the other side of the table, my views have had to change just a little bit. Okay. Very much in support of the bill. This bill, I will point out, the original author is current Congresswoman Colleen Hanabusa from several years ago. And the reason that I attached the type pages in the back is to demonstrate that my position as an individual has not changed since 2000. Actually, since my Uncle Ivanhoe got me involved in the issue of Makua Valley, which is about 40 years ago. We are at a crossroad now where the Army is appearing to come to the conclusion that it no longer is going to use Makua Valley. So the real purpose of this bill is to really set up the discussions to talk about this transition and to set up a process going forward to deal with the transition and to deal with a new entity. Mahalo to all those that have testified in support. I want to answer the question that was community involved in discussing the makeup of the commission and the process going forward, and the answer is yes. Back when Colleen Hanabusa was the Senate President, there was much consideration of this bill and previous drafts of this bill, and of course you still have gentlemen like Mr. Prescott who opposes the return. So we've had about 15 years of community discussion on this issue with regards to Makua. I'd like to also step back and go, in the words of Auntie Frenchie De Soto, it's about time. And that statement is indicative of, during the contentious period where Kaho'olawe and Makua was being debated in society, the kupuna from Molokai, Maui, and Waianae got together, and they basically said, look, we can't fight two battles at one time. So we're going to focus our energies on Kaho'olawe. And so when Kaho'olawe came back to the people of the state of Hawaii, and in its transitional form to be transferred or transformed to the governing entity, whatever that may be, the attention on Makua began. And so there's been 15 years of very strong attention to Makua. And I believe we have convinced the Army that it's in their best interest that they seek other alternatives to training. And if you look at comments coming out of the Army right now, you will see that's exactly where they're going. So I needed to provide that history for you because very similar to Kaho'olawe, we need a process, and learning all of the lessons of Kirk and learning all of the lessons of this transition, this was the best process that we saw that we could put together to assure that this transition. I will disagree with some of the testifiers earlier who said we shouldn't have the Army on this advisory panel, if you will, or commission, if you will. It's important to have the Army on there to have the discussions in the details while this transition occurs. It is extremely important to have both sides at the table on this commission while this transition occurs. And I'll just repeat that one more time. And that's because in the 15 years that we have had these very lively discussions with the Army about the future of Makua Valley, they are now at a place where they are ready to talk transition. So it's important to have that dialogue. So I just want to make sure that from my personal perspective and from my history with this transition, that I believe strongly that needs to remain in place. And with that, I'll be standing by for any questions.
Okay, thank you. Anyone else wish to testify? Yes, please.
Aloha, I'm Sparky Rodriguez at Malama Makua. And there's a lot of lessons needing to be learned from the PKO and Kirk that hopefully we'll be able to avoid with Makua. And we've been dealing with this struggle for a very long time. I believe this is, we support this measure to the degree that it's a beginning process. And I think it's a proactive effort for the eventual return. One of the things I observed at Kaho'olawe is that they received a whole bunch of money and it didn't get cleaned up and it didn't get restored, and it was basically spent. And now the burden lies not only on Kirk but the state of Hawaii and the Hawaiian people. So to avoid that, this would be a positive direction to move in creating that discussion, the dialogue, and how do we fund the cleanup? How do we restore it to a more cultural and traditional appropriate use of the land? The archaeological sites, the history, mo'olelo of the area has tremendous value that I believe will eventually provide an economic engine for the West Side in a more non-destructive way. So we, by the time the lease ends in August of 2029, the Army will have used the valley for 100 years. They started in the late 20s. And for the lease, they paid $1, so it's a penny a year. And in the lease, it says all they have to do is evaluate it, write a check, and leave. They don't have to clean it. In the process over the years, we have been able to work it out with the Army, where they started to do some cleaning, surface cleaning and some subsurface cleaning, as well as archaeological surveys to find out what was there. And we're still in that battle. There's a lot more to be done, and I believe this is a really good start for us to get going and moving forward in this process. So the burden is shared with the federal government and the military and not on the state or the people of Hawaii. Thank you.
Thank you. Anyone else wish to testify? Okay, members, any questions? Representative?
Thank you. William, and if you, I'm sorry, I didn't get your name. If you could come back up.
Also, Mike Naho'opii with the Kirk is here, and I wonder if you would mind being invited
up. This brings back so many memories. I was the one of the attorneys for the Protect Kaho'olawe Ohana for a long period of time, and I've just wanted to make a couple of recommendations. I think this is a positive beginning, but I think maybe it should be kind of worked on a bit before moving forward. First thing is to William. The Navy never got to sit on our side of the table, and we would not be where we are today if they had been on both sides of the table. They need to be across the table, recognizing that they have been the occupier and they are now responsible for turning that property back over to the people of Hawaii. And I think it's a lot stronger position for the people of Makua Valley to retain their own integrity on this side of the table. The other thing is the president could, by executive order, return that to the people of Hawaii. And President George Bush, Herbert Walker Bush, returned Kaho'olawe by executive order. That just happened. I mean, it didn't happen, boom. It had been a long time fighting that whole issue. So that should be, our congressional delegation should be brought into this to say, this is what we want and expect of you, is to, with President Obama, get him to issue that executive order, then put the parties together, Army on that side of the table, and the people of Makua on this side of the table, and work out the details. I believe that there are laws on the federal laws on the books about ordinance cleanup. I don't think they can just walk away, but that might require a lawsuit, but it shouldn't be your money. It should be the state's money defending the state's interest in the cleanup of that land. And then the other thing is, I don't know if anyone has ever proposed putting Makua on the National Register of Historic Places.
It's in process now.
Okay, because all of those things really do help. I think this is a good idea, but I would suggest, if the chair is amenable, of people getting together after, sometime in the ensuing days, and just working on how to make this maybe be a bit stronger and maybe a little bit different focused. Ours came about totally by the Ohana. I mean, we looked at ourselves, the lawyers looked at ourselves as just facilitators. We didn't step in and say, oh, wow, we're lawyers, we know what's right. We were sort of companions and working together, but we sure didn't take the lead. And I think that those kinds of things need to be sure to come out. So it's the people of Makua that really lead the whole thing. And then I would make a big suggestion to get a hold of Boyce Brown. He's brilliant. I got a link to him. I know how to get through to him. And I can remember way back when we were doing Kaho'olawe, and he turned to the attorney for the Navy, and he said, we could get Makua back in a heartbeat. And the Navy attorney just blanched. And the thing was, it wasn't on the table to be doing that right then. But Boyce is brilliant. He's in Texas. He comes here periodically. But I think getting his wisdom, his mana'o, would be just excellent.
I'll be contacting you later.
Okay.
Thank you.
You got it.
Members, please sit here for a moment. I have to recess out temporarily. I'm convening the hearing on notice of decision-making for 9 a.m. Friday, February 1st. It's decision-making only. Members, I'm going to move the decision-making to the end of our other calendar, at the end of our 8 o'clock agenda. I'm going to move decision-making, and that was on the sewer system servicing on Hawaiian homelands. Okay? So we recess on the 9 o'clock agenda and reconvene. Okay, our joint. Okay, my question has to do, I really think that it's time that we move this out, and we, but in its present form, I have to confer with my co-chair, but when I look at it in its present form, it's as if it looks like there's two things going on. One is we say we want to use it so that they're involved in the process of getting the land back from the federal government. So weaved in the language, it appears it's really wants to participate in that whole process of what happens at the end of the lease and how it's going to be managed, and that they're in that process of discussion. And yet there's other parts of it that sound like they're already controlling the valley. If we pass this today, they would be controlling the valley today. Because if you look under powers and duties, it says the department, other departments and agencies shall be subject to the oversight of the commission. And then also it goes into particular things about what's happening in the valley. So it creates a little bit of confusion as to if the commission is, you know, if we passed it, became law this year, they would actually be controlling the valley versus does the commission, if we do it right now, be more in a involvement in the discussion with what's going to happen with them leaving in 2029? Because I think the bill, if we pass it out, it could say we do not believe there should be any renegotiations for release. In fact, it will return, to the state, but we need to create this commission today and now because we got to start these discussions. So there's different ways to approach it, and I'm in its current form. I think it needs to be changed some, but I think we need to move something out. So any comments?
We're open for changes in order to move the vehicle forward, and we can have additional conversation on it. I particularly would encourage Representative Thielen maybe to put something in there if she has a suggestion on prompting the President of the United States to seek an executive order.
Okay.
That would be good language to add.
All right. Thank you.
Right. I think that the best that we can do is offer the lessons that we've learned both in the negotiation process and knowing a little bit about how the Kirk operates today. But really, I think your primary constituency are the people of Makua Valley. And so just as has been brought up, people from all islands supported Kaho'olawe when it was necessary, and so the Ohana members of Kaho'olawe now want to support the Ohana of the broad Makua Valley.
Okay, thank you very much. Okay, members, any other questions?
Question, Chair.
Yeah, Representative Foley.
Mike, it's hard for you to hide back over there. I can, from my experiences with Kanaloa, I can my tendency is to lean more towards what Director Ayla has testified to. From your experience,
Correction, what I've spoken to as an individual. Just for
as
the
an
record,
individual, okay. As Mr. Ayla has testified to today, what would your recommendations be in regards to having the Army being a part of the commission?
My personal recommendation from seeing the process, I used to sit on the other side of the table. I was the Navy commander for the island during the turnover. It was cleaner that one side of the table spoke for the state and spoke for the state's interests, while the other side of the table spoke for the Navy's interests, and creating that dialogue together so that they came to a mutually acceptable position, so that when they moved out of those agreements, everybody sort of was happy when they walked away from the table. The need to create the commission was created for Kaho'olawe. It was created before the turnover because there needed to be a central voice for the state. With the various state departments, they have separate interests in different areas. The Department of Health would talk about environmental issues. DLNR had these issues. Different departments had different issues. But there needed to be one voice communicated to the Navy at that time, so that there was a consolidated position, so that the state spoke from a position of strength instead of a divided interest. And having the commission at the time stand up and develop those negotiations with the Navy, it negotiated from a central point of view and a very strong position that they were speaking on behalf of the governor and behalf of the state interests. And it helped with negotiating all the follow-on memorandums that we had to settle. We had issues about the unexploded ordnance, about the archaeological sites that had to be settled. We had to settle issues about environmental cleanup, and a lot of these memorandums needed one point of contact, not multiple agencies participating in it.
So your recommendation is to not have the Army as part of the commission?
My personal recommendation is not to have it. It would be difficult. I mean, just trying to manage as an executive director. managing a commission that's very diverse with different interests, that is not the interest of what the stated purpose of the commission. I mean, the stated purpose of the commission and the uses of the commission is the management and use for these purposes, which is the traditional Native Hawaiian practices, education, restoration. Those are not the interests of the military. The interest of the military is to utilize it for strength and national defense.
Okay.
Yeah.
Going from that, Mr. Ayla, how about having the Army be a part of the commission after the negotiations and the turnover have been completed? Not during the negotiation process. Any thoughts of that, Mr. Ayla?
You know, the relationship between the community and the Army is going to continue after the handover, simply because of the unexploded ordnance and other issues. So, at some juncture, we still will need to formalize this need. So,
right.
If the committee chooses to take it out and put it in an after transfer section, that's also appropriate.
Just from my experience, it seems that like as you had stated, to have a formal relationship with the Army and the Commission would be a critical part of the success of the Commission in regards to cleanup issues, which are going to continue long into the future, into many years after the turnover takes place.
Yeah.
Go ahead.
If I may, we do have a long-term relationship with the Navy. We signed a memorandum agreement with the Navy that the Navy is still responsible for the long-term issues regarding the cleanup, and we still have communications regularly with the Navy about those long-term management of the unexploded ordnance that remains on the island. And we made it formal as a MOU instead of having a representative on the commission itself.
Okay.
And it was one of the required MOUs that had to be signed with the statute that, with the federal statute that turned over Kaho'olawe.
Okay. Thank you, Chair.
Okay, thank you. Thank you. Okay, members, House Bill 1444 relating to Hawaiian homelands, and which includes submerged lands contiguous to Hawaiian homelands as available lands as defined in Section 203 of the Hawaiian Homes Commission Act. Deborah Chang, oppose. DLNR.
Madam Chair, Esther Kia Aina for the Department of Land and Natural Resources. We oppose this measure for the following reasons. The department, of course, jurisdiction includes submerged lands, and we have a fiduciary duty to maintain these public resources. The transfer of these lands to DHHL, in our view, would hinder the protection of these natural resources, as DHHL currently lacks the necessary expertise in order to carry out this mission. Just within our own mission, because of the complexity of submerged lands, we have our land division, the Office of Conservation and Coastal Lands, the Division of Boating and Ocean Recreation, and the Division of Aquatic Resources, all with overlapping jurisdiction over submerged lands. And as a result, we believe we are in the best position to protect these resources. And again, I just reiterate our concerns over this bill in opposition. Thank you.
Thank you. The Department of the Attorney General. In opposition. Oh, here you are. Hi. Good morning.
Good morning, Chairs Evans and Hano. I'm Charlene Aina, Deputy Attorney General. The Department opposes passage of this bill from a different perspective, but I think there's a commonality between the testimony that DLNR just presented and what the Attorney General would present here. The concern is, well, first of all, our sense is that there's no necessity to transfer title or jurisdiction to DHHL in order for them to accomplish the program that they're proposing. Presently, all public lands are subject to the executive order process in 17111, and there is no reason why that we understood anyway, why that process wouldn't work for purposes of these projects. But I think the most important thing is something which one of the witnesses testified to with respect to the Makua bill, and that is that the state needs to have a consolidated position of strength to speak from. And in the view of the Attorney General, particularly in light of the unsettled nature of the law with respect to navigable waters, as well as submerged lands, and the necessity to interact with the federal government as well as possibly governments of other nations, it's important to speak from a consolidated position, and it's important that when we speak, that we speak with knowledge, coordinated knowledge, and I think what DLNR just testified to in terms of how they use the various parts of the Department of Land and Natural Resources to manage the submerged lands is actually the manner in which the state of Hawaii ought to be dealing with the submerged lands. And so rather than sever title, and in this instance, we would foresee that the lands would be in different parts of the state, but rather than sever, that it's in the state's interest to keep title and jurisdiction at a single control point.
Okay.
Thank you.
Thank you. Department of Hawaiian Homelands.
The Department of Hawaiian Homeland stands on its testimony in support of this legislation.
Okay, thank you. Anyone else wish to testify? Okay, members' questions? Chair Hanohano.
Can I have DHHL and Attorney General? And I guess DLNR. Who's DLNR? Esther. Yeah, I understand the position of the AG and the LNR that you want it to be just like a one agency instead of giving jurisdiction to another agency. But being that, you know, DHHL, and we have a lot of beneficiaries and we have lands that are, you know, on the shoreline and goes into the ocean. Can you, DLNR, can you tell me what have you been doing with those lands? Or you have any development lands, or you have any amount of acreage this would be?
Representative, I don't have any answers to your questions on that, but I could get back to you. I would say that with regard to the objectives of this bill, DLNR is willing to engage with DHHL to effectuate the objectives of this without transferring jurisdiction. Okay.
That answers the question. And do you have any comments?
Well, we welcome the opportunity to work with DLNR. Of course, the issue of and the intent of this bill, we think in terms of providing additional resources to the Hawaiian Homelands Trust, we certainly appreciate, because as you may know, the population that we look out for is a very specific set of individuals, which are the beneficiaries of the Hawaiian Homelands Trust. So we certainly welcome the opportunity to work with DLNR in terms of those assets in the submerged lands or the assets out into the ocean, and would also welcome the opportunity to include our beneficiaries in that dialogue.
Okay. Do you have any comments on the AG office?
No, I think the projects are very doable if we understand what's described. What the objectives of the projects are is to provide an opportunity to practice the traditional and native aquaculture customs in the area adjoining, or in the submerged lands adjoining DHHL available lands. As I said earlier, these lands are available under the existing EO process. Yeah.
Okay, thank you. I have a question. Sorry, Chair. I know that because I deal with aquaculture projects along the Kohala Coast, and the community doesn't really want them. And they're, I mean, obviously they're new, advanced. They're not traditional type of projects. Will any of the, I think it's important, I just don't know if we at the legislature right now need to make a strong policy statement about these traditional native and customary aquaculture practices, if we should make a statement right now about giving direction to the department or whatever, because I know now they have to go through your division. I see Sam Lemo here, but you have that Office Coastal Land Division, and any aquaculture projects goes through this huge, vetting of permitting and projects and the federal government, APA, and on and on and on. So if we believe as a body that we want native aquaculture practices in our waters, should we be really addressing that in the bigger policy discussion to make sure you don't get caught up in the other aquaculture? I mean, you see, because there's a bunch of overlays and permits and processes now in place for aquaculture. Would these...
It would still apply. All of the processes will still apply. Even, I would think whether it is retained by DLNR or, say, hypothetically, the lands were transferred, the laws would still apply. I don't believe the intent is to get exempted from any current state or federal process.
But the way it's written is it's Hawaiian homelands that is all the way to the ocean, and so you just want to go into the submerged lands, like the whole Apua now is going to go out. Is that, am I getting that?
And that's one of the concerns. I mean, that's one of the principal concerns of the Attorney General, is that where is out? I mean, and where are the sides? At this point, the status of the law with respect to the oceans and the submerged lands, I think if you were to ask the federal government where the outermost boundary was, you would get at least 3, maybe 4 different answers depending on which. And what we're saying is the law is uncertain. This project can be accomplished by simply relying on the executive order process. If we were to rely on that, we would not have to make, we would not have to define borders per se. We would simply define the area to be used without, and wait for someone else to challenge us, if you will, rather than commit to something which is definitely in flux, and which we wouldn't want to be the first one to state vis-a-vis the other governments, because we wouldn't want them to then say, but you said it's here, so that must mean it's not further out or further this way or that way. And that's it's a kind of, it's trying to preserve the state's strategic advantage in terms of what is an area that's not as well defined as we would want it to be.
I get that, but we can also make a policy that says the governor shall, through consultation and determination with resource agencies, basically give this land for aquaculture purposes off. I mean, we as policymakers can say we want this to happen and we want to do it by executive order, but that way, everybody's very clear that in fact you can do this. You see what I'm saying? I mean, we can be very strong as policymakers on this.
And as the Attorney General testifies, we urge you to rely on the existing executive order process, or we're actually addressing ourselves to DHHL, but if the legislature felt that it was necessary to be more specific with respect to this and not rely on 171.11, the only point the Attorney General is trying to make is that we utilize the existing situation rather than, and title is what I think is causing the concern, is when you transfer title, you have to define what is being transferred. And at this point in time, if you were to rely simply on the executive order, all you would be doing is defining a land area within what might be an ambiguous greater land area that belongs to the state of Hawaii in order to accomplish the program. And that's all we're saying. So the executive order process appears to us to be the solution to this in terms of providing the context or the ocean for the aquaculture to be in.
We can put that in law, that it will be by executive order. But the other thing is, now with modern technology and liquid robotics, which I'm very aware of, you can actually, I'm sure, legally describe and clearly define what the ocean floor area is.
Madam Chair, I don't want to complicate matters, but one discussion that hasn't been brought up yet has to do with the overall and underlying claims by Native Hawaiians to the Ceded Lands Trust, which includes submerged lands. And I know the Office of Hawaiian Affairs is in the audience. I'm not trying to put them in a spot, but we need to take that into account. In other words, the transferring of title from one state agency to another state agency just may trigger claims by Native Hawaiians who believe that there should be a moratorium on the transfer or sale or exchange of any ceded lands, and submerged lands are definitely within the definition of ceded lands. So when the federal government transferred the Hawaiian Homelands Trust out of the Ceded Lands Trust and then transferred the title back to the state of Hawaii, this ambiguity in the submerged lands is what we have today. But it doesn't mean that the larger class of Native Hawaiian community would not have a say in the universe of those submerged lands.
Okay, thank you. I know we could spend a lot of time on this, but I think that
I want to hear what DHHL Administrator on.
Thank you, Madam Chair. Just a couple of clarifying points in terms of the application of what regulations or laws would apply in this particular case. As I read the language or the amendment, it does indicate that submerged lands would take on the same standing as available lands. And so with available lands, those are lands that are under the public, it's a specific public land trust that is under the jurisdiction of the Hawaiian Homes Commission. And so in that case, that jurisdiction would extend, I believe, to those submerged lands. It is a complicated application of what laws at the local as well as state and federal. As it relates to Hawaiian homelands, people are fairly familiar with the fact that the zoning issues in counties don't apply on Hawaiian homelands. What regulatory in terms of environmental would probably be consistent at the state level with our lands, and at the federal level, of course, likely those would apply to Hawaiian homelands as well. So in terms of addressing that particular question, now we have never had jurisdiction of lands that are submerged or out into the ocean, so that would be a new area that would need to be clarified. As it relates to Esther's point about the ceded land inventory, I just want to clarify one thing, which is the population that is the beneficiary of the ceded land trust is a subset in the 5F laws and being defined as Native Hawaiians, the small and Native Hawaiians that are beneficiaries under the Hawaiian Homelands program. So actually the beneficiaries of that ceded land monies, as it's specified in the Admissions Act, is the same class that is addressed by the Hawaiian Homelands Act itself. So it is a complicated area that would probably need further discussion. I think if it's the intent of the legislature to want to have that clarification of the administration looking at clarifying that to support the native aquaculture, it always helps to have that kind of clarifying language as to what the intent of the legislature is to guide on the executive side what it was the legislature's intention when they passed this. But I just provide those comments to you folks to assist.
Thank you. Members, any questions? Representative Lowen.
For DLNR or DAGs, I'm not sure, but if, just because I'm not aware, if there was an area that was like a marine life conservation district, would that interfere? Like, what would take precedence? Or a protected area?
Your question is if there was an area that was a marine life conservation
district or a protected area or like a fisheries management area that was now...
And you transferred ownership? I would think it would interfere, yes.
So what would be...
From the lawyer's perspective, I think if you were to do that, or you were to contemplate doing that, it would be very important that you made it very clear as to what it was you wanted to have happen as a result of the transfer. Again, I hope that the Attorney General's point is not lost in the discussion in terms of the necessity for there to be, as the discussion was with respect to Makua, and interacting with the federal government, that the concern that the Attorney General brings is that from the state's perspective, it is, as I think the fellow in the blue shirt who spoke about his experience as a Navy commander, it's important that the state speaks with one voice and that the voice be informed. And it's easier to understand, especially since the submerged land surrounds every island, and we are an island state. And there are these various issues that we have to understand before we talk with others. Because if we don't understand, and then we engage in a conversation with the federal government, say, our position isn't as strong as it could be. And so that's the point that the Attorney General is trying to make. And we're trying to suggest that the objectives of the bill can be accomplished without requiring us to get to the issue of what do we own, because what we own, we all have different perspectives on. And from the state's perspective, we would assert that we own all the way to California, if you will. And the United States would say, no, you only own 3 miles out, or whatever. And so that's what we want you to remember when you deal with this.
Okay, thank you. I'm just going to close with a comment. With modern technology and digitization, we're going to zone the ocean. We know it's coming. I think that this proposal is maybe just a little bit premature, but it'll ripen here shortly, and I think this is something we should consider doing. It's 3 miles out, we're going to be able to digitize it. We're going to be able to legally describe it. We're going to be able to zone it. That's where the future is of our ocean. It's coming, and we all know that. But this is like, this makes us think about it, that this is what's coming. And so if there's a way we can move it forward, we'll talk. When we recess, we'll talk about it. But I do think, it's coming. So I appreciate the comments. Thank you.
Thank you.
House Bill 703 relating to memorials establishes the Coastal Memorials Task Force to, among other things, develop standards to regulate the practice of erecting coastal memorials. Charlotte Carter Yamauchi. Comments? DLNR?
Madam Chair, Esther Kia Aina for the Department of Land and Natural Resources. The department has grave concerns over this measure and is requesting that the committee hold this bill. As it pertains to memorials, especially memorials that are located seaward of the shoreline, the majority of these memorials have not been authorized, and what this bill does is creates a task force to set up a regulatory mechanism for these memorials. I have been in discussions with Representative Owana's office, and we have offered to work with her and the community directly. It's a very sensitive matter. Number one, because they're already prohibited. The manner of enforcement and how we go about addressing whether or not a memorial, which is very personalized to the ohana that placed the memorial there, is very challenging. And as a result, instead of trying to formalize a regulatory process for this issue, which would be difficult to enforce even if there were laws, we would ask that you give us time to work with the representative and the community to come up with a way to address this very sensitive issue.
Okay, thank you. Anyone else wish to testify? Okay, if not, members, questions? Okay, thank you, members. House Bill 710 relating to fish ponds requires Department of Land and Natural Resources, Department of Health, and Office of Planning to streamline the permitting process and facilitate the restoration of Hawaiian fish ponds. Requires DLNR to submit a report of findings and recommendations. Okay. So, DLNR?
DLNR stands in support of this measure.
Thank you. Oops. Charlotte Cotter Yamauchi offers comments. Okay, Marine and Coastal Zone Advocacy Council. Okay, in support, Jesse Suki.
Madam Chair, Jesse Suki, Director of Office of Planning. We just have comments on this. We're not sure how this bill is different from Senate Resolution 806, which was adopted by the Senate on April 10, 2012. It directed us to do the same thing that's being requested in this bill, and Office of Planning did it. We set up some streamlining for fish ponds in consultation with our federal NOAA partners for federal permitting of these types of structures.
Thank you. Madeline Letta, in support. Kirsten Faulkner, Hawaii Historic Foundation, support. Tricia Kehalani Watson.
Very briefly, I apologize. I have loud voice. Good morning, Chair, absent Vice Chair, and committee members. Through a competitive RFP process, we were contracted by Conservation International to work on the planning documents related to the Senate bill from last year. While there is some duplication from last year, much of the work has yet to be done. We think this is, while we're just providing comments at this time, we think it's important that the vehicle continues to move forward as we move through the process. While some work may be completed from some of the agencies, we believe that many of the federal permits, state permits, have yet to be completed and addressed. There's still fairly a long way to go. But I want to emphasize, as we did in our testimony, that we have received tremendous support from DLNR, and they've showed extraordinary leadership in this process. Namely, what we hope to have occur next is a programmatic agreement that allows the community organizations and the practitioners to use a single application through the Office of Conservation and Coastal Lands to streamline how they actually obtain approvals. We feel like that is absolutely a critical step to make this a reality. So thank you very much for this opportunity to testify.
Thank you. Anyone else wish to testify? Yes, please.
Aloha, Sarah Collins, testifying as a private citizen, but with a memory. In reading this bill, I see they say that nothing has been done in 30 years. I think that's not quite correct. When I worked for DLNR in the 1990s, actually, I was part of an agency group that crafted at least one and I think two Master Conservation District use permits for fish pond renovation and restoration. Now, those documents may well be out of date and not in effect anymore because the relevant laws and permits to which they're connected have all been updated. But I would suggest that that might be amended there, that perhaps the task force, if they're not aware of those documents, could use them as a starting point. Thank you, because I think this is a great initiative.
Okay, would you be willing to give us written comments? So
yes, I could do that.
Record?
I can send them in. I'm sorry, I didn't realize this was on the agenda as well today.
Thank you. Thank you very much. Anybody else wish to testify? Okay, members, any questions? Okay, members, we'll move on to House Bill 550 relating to public land liability, amends and clarifies the definition of approved public lands in Act 82, Session Laws of Hawaii 203 for purposes of limiting liability for public entities based on the duty to warn of dangers on public lands. Okay, Patrick Jones, support. I'm going to read off all these. I got quite a few here. I'm going to read their names real quick in support. Scott Higgins, Rita Scott, Dr. Paul Ryan, Eva Bosch, Deborah Halbert, Tawny, Megan Taylor, Benjamin Lynn, Charles Derek Krause, Melody Chu, Randy Glidden, Kit Turner, Hayden Huntley, Duke Ong, Christine Miyazaki, John Guris, Rosanna Ho, Sayer Kuchensky.
Good morning, Chair members. My name is Sarah Kuchensky. I strongly support HB 550 because the enactment of 550 can put an end to amok liability concerns, clockwork public land closures, exorbitant wasteful spending of taxpayer money through lawsuit settlements, and under current law, the state has limited to no liability protection from damages arising from injuries sustained by hikers on voluntary trails. It's absolutely imperative we disavow the state of responsibility on voluntary trails for 3 reasons. First, without 550, the state is presented with a completely impossible task, recording and maintaining all voluntary trails. The state cannot possibly know where every voluntary trail is. There are hundreds of miles of voluntary trails that the state does not and will never know about. So how can we expect the state to maintain voluntary trails when the public is creating trails faster than anybody could possibly record them? Furthermore, even if the state knew about every trail, it would be completely impossible for the state to mitigate every risk on every trail or post signage on every trail. Second, because the state is faced with such astronomical and unchecked liability, the state is forced to close down popular public lands, which has detrimental consequences. I personally know Hawaii residents who have lost their job through land closures. I personally know small business owners who are having trouble staying afloat with land closures. I personally know mainland residents who said, I'm not coming to Hawaii because of land closures. Third, when the courts force the state to pay out on settlements, taxpayers lose and they lose big. Recently, the state paid $15.4 million toward a settlement involving 2 hiking fatalities. The money would be better well spent improving the lands rather than draining a finite state budget. The truth is the state cannot mitigate every possible risk. All 50 states, including Hawaii, have some form of liability protection for some dangerous activities. Hawaii has an internationally renowned liability protection package for water sports because Hawaii recognizes that water sports have an integral part in Hawaii's economic structure, and therefore we need to protect access to water sports. Well, hiking is no different. Every year, hundreds of thousands visit Hawaii with the intention of going hiking, and hiking is going to become increasingly more popular. Now, some may argue that the state has a duty to protect its citizens, and therefore 550 is invalid. However, that argument is a logical fallacy and a proxy for their true intentions. As previously mentioned, the state cannot maintain every voluntary trail and protect hikers from every possible risk. It's just not possible. So I ask you to vote aye in passing 550 and bringing Hawaii to the national standard. Time to move forward and get with the times. Unchecked liability hurts everybody. I deeply thank you for your time.
Thank you. Jennifer Mui offered comments. Okay, DLNR.
DLNR stands on our testimony and support.
Dawn Sperlin, Corporation Counsel, City and County of Honolulu. In support. Bob Toyofuku.
Good morning, Madam Chairs, members of the committee. I'm Bert Sakuda here for Bob Toyofuku, who is juggling concurrent hearings. We are actually in partial agreement and partial disagreement with this measure, and this is the reason. The voluntary trail situation really spans a very broad spectrum. At one extreme, you can have trails created by pig hunters in very remote areas, and it is, of course, impractical, if not impossible, for the government to discover all of these and maintain them. We agree with that. On the other extreme, you can have voluntary trails that are a part of the official trail system because people over time have gone off to the side and come back. Typically what you find is there'll be a side trail, it'll go off a bit, they'll join back up with the official trail about 50 or 100 feet later on. For those trails, there is no added burden to the state to sign them and maintain them properly. The need is there because for the other trails where you have experienced hikers, you have hunters, those trails, A, are not used very often. They're used for specific purposes by these people who are experienced. They really don't need the protections of this act. For the regular trails that are used by casual users, families, retirees, tourists, city dwellers who go hiking once every 5 or 10 years, that's where these protections are needed. And they're going to be using the official trails in the official parks. For those situations, there is no extra burden, and there's a need to provide for the safety that's provided by this act. So we have offered an amendment for the consideration of the committee that says, go ahead and exclude all of the voluntary trails unless they are a part of the official trail or so close to it in proximity that it appears to be to the average person. Because in those situations, there's no way that someone like myself, who is not an experienced hiker, or just a regular mom and pop taking their kids out, there's no way they're going to know which is the official trail and which is not, because there are no signs that say that. And so in those situations, it just makes sense that if it's a part of it, and there's no added burden and there's a need for protection, we should have it. Thank you.
Okay, thank you. Anyone else wish to testify? Yes, please.
Good morning, Madam Chairs and committee members. My name is Deputy Attorney General Robin Kishi. I don't know why our written testimony was submitted late, so let me just highlight what was in there as well as to address some of the things that Mr. Sakuda attested to. As you all well know, some of the state parks locations are constructed and maintained by the Parks Division. That's barely 2% of all of the acreage under the state park system. The mission of the Department of Land and Natural Resources, and in particular the Parks Division, is to retain as much as possible the natural, historic, and culturally significant, as well as the wildlife conditions of those park lands. Unfortunately, as well as fortunately, we have locals as well as visitors who deviate from sometimes and stray off of the paved official trails. There is an extensive statewide trail system which has been constructed, maintained, well kept. There is, in addition to that, for that statewide trail system, an extensive signage system on top of that to make sure that our locals and our visitors heed the warnings and to be careful for their own safety. One of the costly examples that you may recall from last year was the Brem case, in which the state had to effect a settlement in excess of $15 million, $5.46 million of which came out of general funds. The other remaining nearly $10 million was funded by the state's excess insurance carrier. You can be certain that in the future and for years to come, we will be paying increased premiums for the $10 million that the excess carrier funded. But also, the $5.46 million definitely did not go to the Department of Land and Natural Resources for operating and maintenance. It went outside of state. It went to litigation costs. Since the Brem settlement last year, there have been several more incidents just in last summer alone, which have resulted in deaths, one of which occurred just a few weeks ago. I went to the site yesterday. It was out by the Makapu Lighthouse. In order for the hiker to have fallen to where his body was recovered, he had to have deviated from the paved trail, climbed onto crumbling cliff faces, and then fallen. There's no way that the state parks could have prevented something like this. They have not the resources nor the staff to continually monitor as well as to find all of these voluntary trails that are created each and every day. The state parks is not like the city parks or the county parks. Much of the acreage under the jurisdiction of the Parks Division is really in remote locations. The network of voluntary trails, oftentimes tributaries are made from the official trail system and then branch out into these remote areas. Many of these locations are the last place that our experienced staff park personnel, as well as experts, would even think people would be accessing. Unfortunately, this network of voluntary trails continues to grow every year. What happens is that when the state closes down an area because we've had a tragic accident, 2 or 3 more voluntary trails will branch out from the spot that they just closed. When the state signs the voluntary trail to warn people not to access this area, people will disregard the signs. Unfortunately, the networks and the tributaries leading from the official trails are more than a managerial challenge. It becomes a managerial nightmare. The state, unfortunately and necessarily, is always behind the next accident. We strongly recommend passage of this bill. I think the gentleman who testified first summarized the issues so well. Either millions of dollars will continue to be drained from the general fund and not be devoted to Department of Land and Natural Resources budget. Thank you, and I will remain for question. And again, my apology for not having timely submitted the written testimony.
Thank you very much. Anyone else wish to testify?
Good morning. I prepared some written testimony, but didn't have the opportunity to submit it, so I'll just read that first of all. I'd like to thank co-chairs Evans and Hano for the opportunity to present this testimony, and members of the Joint Committee. I believe this is a matter of great importance not only to me, but to the entire community, at least the portions of the community which pursue outdoor recreation or pay any taxes. We live in a culture which permits, tolerates, and often even glorifies a wide range of recreational activities, many of which are inherently dangerous. We treasure our big wave surfers, yet we allow them to accept the risks associated with their actions. We would never dream of telling them that a given day is too big to paddle out, or a particular reef is too shallow, too sharp, or too dangerous to surf. Instead, we've established the appropriate legal statutes, such as Acts 82, 170, and 190, to protect the state and the taxpayers from any claims resulting from such recreation. Hiking mountain trails and rock climbing in its various forms have both continued to become incredibly popular here in Hawaii. We should treasure these hikers and climbers as incredible athletes as well. Instead, out of fear of litigation, our state DLNR has systematically taken away the resources that allow these groups to participate in their chosen forms of recreation. Oversight of all the possible locations for these activities, as several others have testified to, isn't even remotely possible. So we're left with the option of allowing these practitioners to take responsibility for their own actions, just as big wave surfers do. This bill is one step in that direction. So, therefore, passing House Bill 550 to amend the definition of improved lands will protect the state from liability resulting from these potentially infinite number of voluntary trails that are popping up continuously and return the deeply treasured natural resources to the community. So this isn't necessarily just about preventing future lawsuits. It's also about preventing closures out of fear of these lawsuits. And currently, the rock climbing community has been completely disenfranchised and shut down. Almost all of our crags are closed right now by DLNR because of potential for lawsuits. So I'm here to humbly request that the legislature act to protect my right to pursue outdoor recreation without having to fight tooth and nail to maintain access to public lands. Thank you.
Thank you. Anyone else wish to testify? Yes.
Good morning again. Thanks for having us. Mike Richardson, resident of Hawaii. Heard some real good testimony today. There's not much I can add, but just some quick points. Real quickly, this is what a closed climbing area looks like.
May I have that?
You got it.
There's people watching around the state. I don't know if they can zero in on that, but...
That's our main climbing area on the North Shore.
Okay.
And as Mike behind me just noted, all of our climbing is essentially closed on the island of Oahu. So just some quick questions for everyone. You don't have to answer, just think about it. How many folks here present have in the past or do currently enjoy hiking, biking, climbing, hunting, paragliding? And how many present have in the past or do currently have used involuntary trails? Okay, now regarding the past 10 years of attempts to amend what's really part of a bigger picture here, liability laws that need change in Hawaii, why is it that only trial attorneys oppose these bills? Is it because they know more about the dangers of hazardous recreation than the rest of us? Or is it because they're more concerned about public safety than anyone else? Regarding Act 190, which was passed in 1996, which absolves Hawaii of most ocean and beach-related liability, why do we absolve ourselves of that liability? Is it because ocean sports are so key to tourism? Is it because they're so tied to our image in Hawaii, or the idea about past and present culture in Hawaii? Are hiking, paragliding, biking, canyoneering, ecotourism in general, and the opportunity to enjoy those activities in Hawaii unimportant to tourism? Are these activities increasing in importance? Why don't we have similar legislation for those activities like we do for ocean activities? Regarding the fact that 16 other states have fairly comprehensive hazardous recreational statutes, what is unique about the situation in Hawaii that prevents us from accomplishing the same? Is there something extra complicated about the situation in Hawaii? What do other states know, or what is it that we don't know? We've heard several folks testify about the case last year in March 20th, $15.4 million. Could that money have been better spent on watershed protection, which we heard so much about on Monday? Consider the vast number of accidents that happen every month, year after year. Does status quo liability legislation prevent these accidents? No. It's going to happen. DLNR can't control it. It's time for sensible liability legislation in Hawaii. Please support the current bill, and thanks for your time.
Mr. Richardson, if you can submit written testimony so it becomes official record.
Yes,
we
ma'am.
appreciate it.
Okay.
Thanks.
Thank you.
Thank you. Anyone else wish to testify? Not members, any questions? Oh, please.
Hello, representatives. My name is Megan Taylor, and thank you for the opportunity to speak on behalf of this bill. Myself, I'm very new to the sport of climbing, and I've been climbing for about 5 months now. And I mean, what I've witnessed with climbing is, I mean, very inspiring sport. I mean, just as surfing is the heart, you know, of many people in Hawaii. The sport of climbing, you know, it's, you know, the adventure we all believe in life. You know, there's so much technique. There's so much, you know, what I first did, I fell in love with the sport when I first took a class with Climb Aloha, a very professional organization. And it was so positive because they, you know, they would have a group teach very well the techniques that you need to climb safely. And, you know, to be honest with you, I was probably the slowest learner of the class, but I fell in love with it. What I saw, you know, was a kid, you know, there was a child, you know, with the mother and conquering, you know, challenges, just like other sports, you know, getting maybe a dream if that's something they like. If they don't, you know, that's okay too.
Megan,
yes.
For sake of time, tell us what you think about the bill and why we should support it or not support it.
I think it's so important because people in life, like climbing, hiking, you know, people want to explore nature. It's a positive thing. It helps people, you know, grow and have inspiration in life. The bill will benefit the whole state because basically, just like surfing, you know, people want to get out there and they do the 25, you know, foot waves, and they inspire people, and it's great that they do that. And I think just like rock climbing or hiking, you know, people that, you know, mountaineering, that's very inspiring for people. It's people's heart. You know, people that live here, it might be a smaller number of people, but it inspires their life. And without being able to, you know, do those activities, people kind of wither away. They get, you know, it leads to inactivity and, you know, a depressed society. So the bill, I think, is fantastic because, you know, it will let people be able to live their life, have freedom, just like surfing, just like the ocean, but on land. You can always have safety precautions, signs for warning, you know, to give people the opportunity, general public, to say, no, I don't want to enter this area, you know, but not close it off where people can't participate in some, you know, in a sport that they love. So the bill, you know, will right now you can't climb anywhere without getting, you know, fined or breaking the law, and people don't want to do that. So, you know, I think it will help everybody, it'll protect the state and help people, you know, strive for, you know, their goals, like other states that have classes, you know, for kids to climb, and they love it, and it's not a negative thing. And just like any sport, football, basketball, baseball, surfing, you know, there is some dangers, and so the bill will protect the state and let people, you know.
Thank you, Megan.
Thank you for the opportunity to speak.
Okay, thank you. Anyone else wish to testify? Okay, members, any questions? Yes, I'm sorry. Representative Foley?
I have one question for DLNR. Would the passage of this bill help to keep open places that DLNR would otherwise close because of liability issues?
Yes.
Okay.
My name's Steve Thompson. I'm with State Parks. Yes, it would allow us to keep places open.
Okay, and these are sites that would be important for not only recreational purposes but cultural purposes as well.
Yes.
Okay. That's all I have, Chair.
Okay, thank you. Representative Long?
Do you have any sense of the, compared to the total number of people who go hiking on maintained or unmaintained trails, what percent of people actually fall and get injured or die? I mean, 1% or less than 1% or more than that?
We don't have those answers, but we could get back to you, Representative.
Okay. Do you have a sense of, a number, many people go hiking safely with no incident every day?
Oh, yeah. You're correct. The thing that kept coming up in my mind is I was thinking on Kauai, the Nepali coast or the Wailua River Valley. It's thousands and thousands of acres, and yet we have particularly designated areas that we maintain and we improve and we sign and we provide services, but the bulk of those areas are just natural. And yet without the change in the law, we're subject, the whole area is subject to needing to be signed. And it's just not practical. And plus, you look at the picture that went around. You want every area to be looking like that? I mean, you would have hundreds of thousands of signs if we did every possible cliff or place where rocks fall.
Mm-hmm. And then people assume, in your opinion, do people assume a certain amount of responsibility for themselves when they go hiking? I mean, even if a place is signed and well-maintained, there's still accidents from, the managed trails, from paved trails, from places like Kuli'o'o. I think more recently, where someone fell, and that's not one of these extreme hiker places. So, I mean, I'm just trying to make the point that we can't assume there's never going to be any injury when people engage in this kind of outdoor activity.
That's correct.
Okay. Any more questions? Okay, I have a question for the Attorney General. Thank you. I was just reading the bill and thought that we want to move it out, but there might be some inconsistencies in language. There's on page 1, it talks about volunteer trails that are not part of an official trail, whatever official trail is. But then you get into the next page where it talks about state park system, parks, parkways, which are developed and maintained by the state, and then it talks about counties' park systems, which are developed or maintained by the county. And then I'm thinking possibly we'll enter with some concessionaires or vendors possibly in the future that might develop and maintain our parks for us. And so we're not even putting in potentially a public-private partnership. And maybe we need to even put language to cover that scenario also, because we may have other people maintaining it as a concessionaire, for example. The other thing is we get down into excludes volunteer trails created by users of the public systems that are not part of the statewide trail and access system, ocean and submerged lands, and any public beach park. But then it's not referring back up to parks, park systems, parkways. It's talking about a trail and access system. So it seems like we just need to get a little more clarity on it.
No, let me explain why it is drafted the way it is. Maybe
Okay.
that will help. The statewide trail system is not just on parks property. The statewide trail system may be on unencumbered lands or other lands that are within the Department of Land and Natural Resources, but not necessarily under the Division of Parks. So the statewide trail system is truly statewide. I mean, it covers all the islands and irrespective of the classification of the land on which the trail is constructed and maintained. So this amendment was carefully drafted to actually get rid of or to correct vague language and ambiguities to make sure. I mean, we do have to mention the statewide trail system, because we have to distinguish between voluntary trails that are created by members of the public from the official statewide trail system, whether it's on parkland or other DLNR land.
I understand, but what you're saying, volunteer trails created that are not part of the trail and access system or any public beach park. But we have Mauna Kea. We have other parks that are Malka. They're not beach parks, and so I just want to make sure we're covering all parks, park systems, parkways, because this talks about the trail and access system. Unless your definition of trail and access system includes every park in the state.
No, why there's the exclusion here for the the voluntary trail system is not part of our official system. Okay, we don't maintain it.
No, I get that. I get that, but it's saying
beach parks we don't. Madam Chair, beach parks are covered under a different bill, under the Ocean Safety Bill. And so in order not to create further ambiguity, we're making sure that we're distinguishing everything out. So we're actually trying to make sure that there are no ambiguities. And we also would prefer that there not be any amendments to the language other than what's presented in the bill. Such as what Mr. Sakuda had suggested. Let me explain why. Because what you will be doing if you do what Mr. Sakuda suggests, which is to keep the state on the hook, in other words, for those voluntary trails or tributaries that lead off of the official trails. What you're doing is you're just merely creating another quasi-official or unofficial trail system for which the state parks has to now maintain. Right. And you're inserting it in the language. And then we'll have like another extensive signage system for that quasi-official statewide trail system.
I just don't want to get us in a position where the official trail, it could be argued the official trail versus voluntary trail is a trail that's signed, because that may not be the case. Or it may not even be paved. That not be the case. So official trail versus volunteer trail, I just, I want to defer it so I can have further discussion.
Let me explain. There really is no ambiguity within the Department of Land and Natural Resources. There is an official statewide trail system. Everything is inventoried, so there will be no ambiguity. Whether or not it is signed, whether we've signed in the past a voluntary trail or not, that signed voluntary trail is still not part of the statewide official system, which is inventory.
Okay, you go to Puna Beach State Park, where, people go there. The people create these voluntary trails that weave all through that little park system along the beach there. And so you're telling me the official trail is obvious versus the voluntary trail?
I don't understand what you mean. It should be obvious to whom? To the parks people? Yes, no. It is. To the public? Yeah. Oftentimes, the state trails are signed. They in fact inform you to stay on the trail more often than not. But people will not heed signs. Madam Chair.
Right. Okay. Thank you.
Thank you.
Okay. Next, we have House Bill 1268. This allows 999-year homestead leases to be assigned to trustees of land trusts that are created for managing and holding the homestead leasehold estate for the benefit of the lessee and lessee's family members. Lalani Teal.
Aloha.
Morning.
Mahalo nui loa for the opportunity to testify today. As you may be aware, the 999-year lease program was something that was started in the very, very early years of the territory of Hawaii. It was originally envisioned during the kingdom days, but by the time that it was implemented by the territory, it had many problems. Today, there are many families living on these lands that are looking for ways to solve these problems. The primary root of many of the problems is a successorship structure that is rather confusing, for one thing, and it's very difficult for the families to manage, as well as many legislative changes, not many, but a significant legislative change in 2000, and many cases, legal cases that have arisen since then, unfortunately, with family members fighting family members. Now, as a peacemaker who works in the Hawaiian community, I've worked with many families on these leases. They're looking for solutions. So House Bill 1268, essentially all that it does is it provides the option for, rather than an individual name to hold the lease, for trusts that the family creates, including those who have the interest in the lease, to be able to create an Ohana Land Trust that would then hold the lease. This simplifies many problems for the future. It resolves the problem of successorship from that point on, because that's determined. It resolves problems that could be associated with personal debts, say medical debts that could be affect one member. It resolves many other, it resolves matters of governance that have been difficult for the state to deal with in terms of managing, in terms of being able to communicate with all of those who are connected with these lands. So I am in strong support of House Bill 1268. I must say that the families that I work with are also, in general, in very strong support of this as an option. It's not, it wouldn't mandate them to do anything, and nor would it mandate the state. It doesn't cost anything at all. It's simply an additional option, but an important one that would be a positive step forward in resolving many of the matters that affect these leases.
Thank you.
Mahalo.
Mahalo. Michael Patagon Jr.
Oh, he's not here. He's actually out of Hawaii right now. Yeah.
Okay, thank you. DLNR.
DLNR stands in support of our testimony. Stands on our testimony in support.
Okay, thank you. Oswald Stender. In support. Anybody else wish to testify? Any members, any questions? Okay. Next, we have House Bill 583. DLNR. I'm sorry. Oh, I can go back. I'll go back.
1292.
1292. Okay, I'll go to 1292. Okay, members. 1292, DLNR.
Yes. Esther Kia Aina for DLNR, committee members and chairs. DLNR has no objection to this measure. However, we recommend that remnant sales and the issuance of easements and licenses to utility companies be exempted from this requirement. Thank you.
Okay, Nancy Devlantis in support. Anyone else wish to testify? Okay, yes.
Aloha chairs, members of the committee, Sterling Wong, Public Policy Manager for the Office of Hawaiian Affairs. Our Board of Trustees has not taken an official position yet on this bill. At the staff level, we're still reviewing it, and I think we're inclined to support, but we just want to make sure that the bill itself and all the amendments comport with the Act 178 process, the Act 176 process, which set up the legislative approval process for the sale and exchange of lands, is followed. That was, of course, our settlement of our HCD CHR ceded lands lawsuit, and Act 176 was amended 2 years later in 2010 by Act 169 to create a number of a process for getting resolutions to OHA in advance to make sure we can see what lands are going to be sold in advance and determine whether they're ceded or not, and we can then testify appropriately. So we will be making a recommendation to our board, but again, our main concern is that the reporting requirements are maintained under the new process proposed in this bill.
Okay, can you provide written comments for
Sure.
for official record? Okay, thank you.
Thank you.
Thank you very much. Anybody else wish to testify? Members, any questions? Okay, we'll go to House Bill 583. DLNR.
Good morning, Chair. Russell Suji for Department of Land and Natural Resources. We did send in testimony in opposition. Basically, this bill is calling for an asset management system, and it would, and the way we read it, it would actually impact what an existing law, Act 54, which the department is working diligently on trying to come up with a system for the land side and the land management side of state lands, and in particular those that have been set aside to other agencies, and try to get a handle on what kind of leases they have encumbered those lands with since our transfer to them. We do support and recognize that perhaps at the state level, at a higher level, there may be a need for an asset management system to help manage those entities that manage public facilities. However, Land and Natural Resources is just that. Our department's focus and mission is on the land and the natural resources, and many of the public facilities on these lands are actually managed by other entities. One big one in particular is Department of Accounting and General Services, as well as others, University of Hawaii, the DOE, etc. So, we do oppose that part of the bill, which mandates the DLNR be the lead on this bill.
Okay, please stay and does anybody else wish to testify? Okay, members, any questions? Okay, I have a question for you, Mr. Suji. It says the department has already contacted with the vendor to develop a land inventory as mandated by Act 54, and the vendor is working on the development of a public land trust information system.
Yes. That was
Part of that land inventory, because the way I read the bill, is to also identify potentially how many buildings are existing on the land. So when he inventories it, is he inventorying, is it pastoral, agriculture? It actually has buildings on it, potential for lease, or, I mean, I can see why someone would want to introduce the bill to really understand the assets that the department manages. So is your vendor going to be more specific?
The vendor, as I recall, the act was, and I think I have my IT person, Derek Urbilla, sitting in the audience. He can come up and clarify if I misspeak, but the act was more designed to putting missing parts of land and natural resources that have been set aside to other agencies that we no longer track at the department level. We do manage our inventory, the ones that are retained by the department, whether for like in Banyan Drive cases or in other parks, etc. But Act 54 was designed to try to get a handle on the land and natural resource side, not so much the asset management side. I can tell you, maybe 3-4 years ago, the department, and we're not, and this is why we say maybe an asset management system may be helpful for certain purposes. We looked at a possibility of implementing something like that for our state park system to help them manage the park facilities. We consulted with the City and County of Honolulu Parks Department, who had actually did one asset management system, and it took them many years, to somewhere in the field, a number of $20 million, many meetings with the unions, and who is going to populate the information about who's going to evaluate the building, how good is that roof, is it going to be the guy on the ground, or is it going to be an engineer, and who's going to go out in the field. It was very extensive, and so
the way this bill is written is this is to be an inventory asset management system for all state lands, and you're talking about lands under the University of Hawaii, which we have no control, Department of Education, and many of our public facilities, like this facility, is probably managed, I guess, by DAGS, Department of Accounting and General Services. But Act 54 was not intended to be an asset management system.
Okay.
More of a land management system. Our current system right now at land, if we didn't have Act 54, we have a system called the SLIMS, the State Land Inventory Management System. But really, it's the focus and as much as up to date as we can, information on there on current leases and what's going on the land is what we have under our management jurisdiction. A lot of times, that's why the EO process is talked about earlier by the Attorney General. Once you, it's very similar to giving away fee, but you're not. But you're turning over management to another agency, and they from there decide whether they want to lease it, whether they don't want to lease it, whether they want to go out and build a building on it.
But if you have the lands that clearly are just under your jurisdiction and nobody else's department, when you inventory it, and when you're doing the inventory now, will they identify if there is buildings on it, what kind of buildings are on it, warehouse, industrial building, office building? Will they not identify what the facilities are?
We've been asking them for all encumbrances. So I suppose they could provide the buildings, but the way I read this modification to Act 54, it would probably require us to collect a lot more information, a different data set altogether, different attributes. It may actually require us to take a look at what's in the buildings, the units, the square footage, the tenants, conditions, structures. These are things that we're not currently collecting for Act 54. So I think it goes well beyond that.
Okay, well, we should talk about this because, you know, DAGS, who does state buildings, clearly should have an inventory of what the public buildings are in the facilities, so we know. I mean, we are the owners. All the citizens out there that are watching, we own these public facilities, so we should know what the inventory of those facilities are. So, again, like this says, you know, if they're sitting there, potentially we as the legislature can support your department in possibly giving you more staff or whatever to utilize these facilities. So the inventory, I can see an importance of knowing what we have on DLNR controlled lands.
And even that was a monstrous task just to do it for state parks when we looked at it, and many, many years and additional staffing. I think I informally have had discussions with DAGS about such a system, and I mean, they understand the benefit of it. It's just that they oftentimes are, you know, they working after the fact. Like there's a leak and they're going in to repair it, or there's a CIP for a new building, they go in and build it.
Yeah, I'm not talking about inventorying the condition. That's not what I'm talking about. Just knowing what our assets are. That's all I'm saying. Because as you know, like I said, the citizens have paid for these facilities and buildings.
We point out that we think maybe at the state level there is a need for that information. Again, when people or agencies come to DLNR and ask the board for a set aside of land because they want to build a school, the board doesn't get into managing the construction of the school and et cetera, They go in and look at the purpose and they say, okay, and they approve it and they set it aside. After that, the Department of Education, for example, together with DAGS, will go ahead and construct the building. That is outside of our jurisdiction. We don't manage that. We don't ask to review any plans. We don't, it's just, the staffing right now is hard enough just keeping up with the request for such.
Got it. Okay. Thank you. Thank you very much. Okay, members, House Bill 939 relating to enforcement of violations by the Department of Land and Natural Resources provides alternative civil enforcement options that may be utilized by the Board of Land and Natural Resource in the processing of natural and cultural resource violation cases. Office of Hawaiian Affairs.
All stands on its testimony support.
Thank you. DLNR. Thank you. Mark Fox, Nature Conservancy. Oh, I'm sorry. Do you want to testify?
Yes. Good morning, Madam Chair and members. Ben Seeley of the Department of Land and Natural Resources, and we want to offer our additional comments, and we believe that this bill will provide additional process in our DNR current civil enforcement options, and it will provide flexibility to both the department and also the parties who are involved in our process, mostly the alleged violators in our cases. And we think that it's going to provide additional revenue for the department as well as more savings in our process. So I think it's a good measure that we should adopt. Thank you. If you have further questions, I'll address that.
All right, thank you.
Thank you.
Thank you. Mark Fox, the Nature Conservancy.
Thank you, Chair. Good morning, committee members. Mark Fox for the Nature Conservancy. I'll be really brief. We too support the bill. I just want to note, you have heard in past years, I know you've heard already this year, and you're going to hear more this year, very often very controversial measures about natural resource protection and management and different viewpoints from conservation groups and user groups. This is an area that I would venture to say virtually everybody agrees on. That improving the capacity of the Department of Land and Natural Resource to enforce our natural resource laws, the ones we have on the books, and to encourage compliance and find a variety and a flexible number of ways to create that enforcement and that compliance is in everybody's interest. And I think you'll find, if I'm right, nobody else is going to come up and oppose this. I think you're going to find pretty universal agreement here. This gives the department another tool for it to impose civil penalties when, criminal penalties are either inappropriate or unworkable. It's not appropriate to bring a case all the way to the judicial system, which is time-consuming and costly. It gives them some flexibility to look at community service, license revocation, things like that, to enforce the laws we have on the books right now. So we strongly support it. Please keep it moving. It came before the legislature last year. I can't remember why it didn't pass, but it's worthy of passage. Thank you.
Okay, thank you. Sarah Collins, Society for Hawaiian Archaeology.
Aloha. Thank you, committee chairs. I apologize for the late testimony. We support the intent of this bill. We think that although we have strong historic preservation laws, enforcement's always been a problem. And we're all for anything that is going to be creative and flexible. We just have two primary comments on the bill. One is that if community service involves historic sites, say restoration or caretaking, that this only be done with an established program and under the supervision of an agency like State Parks or State Historic Preservation Division. In other words, that people are working within a context on a historic site. And secondly, we mostly have questions which we think will be resolved as this bill moves, and that is we're assuming that the archaeological permit is one of the permits or licenses that would be suspended as a measure of dealing with the violation. We're just not sure from the wording of this how this would comport with the sections of 6E that have civil and administrative as well as criminal penalties, which oddly enough don't include pulling permits either. So maybe there needs to be some statutory coordination or whatever. Thank you very much for the opportunity to comment.
Thank you. Members, any questions? Okay, thank you, members. Move on to House Bill 415. This authorizes each county to establish a land management advisory committee, requires DLNR to receive approval from the appropriate land management advisory committee prior to adopting any county-specific rule that affects the use or management of land or nearshore waters within the county. Office of Hawaiian Affairs.
Aloha chairs, vice chairs, members of the committees. Sterling Huang, Public Policy Manager for the Office of Foreign Affairs. OHA opposes HB 415. It would be really problematic to authorize these county committees to have essentially veto authority over decisions made by the DNR, which is essentially the only agency constitutionally mandated to protect and manage the state's fragile natural and cultural resources. It would just hamper the DNR's ability to do its jobs, to fulfill its mandates. And we also want to note that throughout DNR's rulemaking process, there are opportunities for counties to participate in the rulemaking process. DNR has specific members on its board that represent counties. In addition, the rulemaking process requires public hearings, which are often held in the individual counties that are impacted. So for these reasons, we ask that the committees hold the bill. Mahalo.
Thank you. Carrie Marks, in support. Sharon Wilford, support. Barbara Cuttance, support. Robert Patrici, support. Shannon Rudolph, support. DLNR.
Esther Kiaina for DLNR. DLNR opposes this bill. We believe that existing mechanisms and processes currently exist to provide for input from the various levels of government, including the public. And if the bill was recrafted to actually have this committee be an advisory capacity as opposed to an approving entity, then it would fulfill its intent. When you say it's going to be an advisory committee, then the authority of it should not be to have the full authority to approve. And so we have grave concerns over this bill, and we oppose it.
Okay. Thank you. Anyone else wish to testify? Members, any questions? Okay, thank you. Members, on to House Bill 989, relating to fish, requires DLNR to calculate penalties for the unlawful taking of each saltwater or freshwater non-game fish or any specimen of aquatic life by multiplying each separate species unlawfully taken by the quantity of that species taken, using the appropriate fine based on the species of the fish or aquatic life. Matthew Ross. Support. Marshall Myers. Support. This is all support. So Anthony Nahaki, Ula Karmientke, DLNR. Christian Schmidt, Ben Kazuga, Bertha Pasabi, Chris Buerner, Nicholas Ramirez, Pete Pasabi, Randy Fernley, Taituna Fa'avesi, and Christopher Jury. All of it was in support. Anyone else wish to testify? Okay, thank you, members. Any questions? Yes, please, Representative Cullen.
Real quick, what is a non-game fish?
Under statutes, Hawaii freshwater game fish were introduced to Hawaii, and so those are considered game fish. If it's not one of those listed freshwater game fish species, then it's a non-game fish species. On the marine side, there's no distinction between marine and between game and non-game species.
Okay. So on the marine side, no difference then?
Yeah.
Okay, thank you. Just wanted to clarify.
Okay, thank you. Members, any other questions? Okay, thank you, members. We'll go to House Bill 933, relating to special shoreline encroachment easements. It provides the Board of Land and Natural Resources discretion to grant easements for less than fair market value for structures that were authorized by a government authority and constructed landward of the shoreline within the record boundary of the landward property at the time of construction, but are now located seaward of the shoreline on public land. Jesse Suki? Okay. Thorne Abbott? Okay, so the Office of Planning, Jesse Suki provided comments. Thorne Abbott's in support. DLNR?
Chairperson Russell Suji for the department. This is an administration proposal, and just shortly before our submitting our written testimony, we had discussions with Office of Planning and came up with an amendment that we think is we both agree on that is best to preserve to be added to this bill. Basically, we're requesting amendments including revising Section B to note that the granting of an easement shall not be construed as state approval of any risk taken by a littoral landowner. In addition, inclusion of a new subsection C requires the board, DLNR, consider public policy factors such as protection and preservation of the natural shoreline, public access along the shoreline, and long-term risk to life and property from coastal hazards when in its approval of an easement. And we include that language in our testimony on the second page. I think your description, or our description, and you're reading our description of the bill, hit it on the nose. I know it's a mouthful, and I'm here to answer any questions. But this is certainly to address not new shoreline structures that are being built on our land, but to address older structures that was actually built on within the private record boundary, nowhere near the shoreline, and actually with some kind of government approval as well. And today, unfortunately, the structure, there are structures now within the shoreline, and so we are trying to address that situation and try to be fair to the homeowner.
Okay. Thank you. Anyone else wish to testify? Members' questions? Representative Thielen, followed by Kaufman.
Russell, do you mind coming back up for a minute? There are some of these, when we're talking shoreline, we're talking beachfront properties, right? Or oceanfront properties. Okay, yes. And some of those structures have been constructed partially on state land.
Yes, and this is, and for those, what this bill tries to address is those that is totally within the private record boundary. Now, when you have one that is partially in and out, they would certainly have to pay, if I envision, even if this bill was to pass, they would have to certainly pay for that section that was clearly protruding into the state land from day one.
Yeah, my problem with the bill is not getting fair market value.
Okay.
Because you're going to have a hybrid, and you're going to have some that were fully on state land during the past century, or maybe even before.
Okay.
And so then and there have been some where you've had these confrontations with DLNR, and DLNR's backed down and allowed people to go ahead. So the whole purpose of this is really to reduce the amount of money coming back to the state, to make it be just a nominal amount. And does that money go into DLNR, or does that go to the general fund?
I believe 20% goes to OHA, because if it involves the shoreline, because it will be ceded land. And I believe 80% goes to the beachfront currently. But just to, if I may say something about what you were talking about there, Representative, with respect to the structures that was clearly built on our land, the state land, we definitely require easements when we find out about them, easements that pay fair market value. This bill is not trying to address that situation, but to address a different situation, which, and I'll be very frank, up until very recently, DLNR did not require easements for these structures that may have been fit this scenario where they were built originally within totally private property, but they have since learned, because of the shoreline has moved in, it has now you have the structure in the ocean. There was serious questions legally and from a policy side. Legally, meaning the question was, is that really our land? Yes, we're facing with some Supreme Court decisions that say littoral owners or shoreline properties that may have once been private property, but now the shoreline is now inland, that's state, but it never addressed what about structures that was built there previously and previously allowed and permitted. And it still hasn't been addressed, not by this Hawaii Supreme Court yet. Meanwhile, when I reverted back to my position, which I am in now as Administrator of the Land Division in 2010, I've since then been involved with lawsuits involving not necessarily a wall or a man-made structure, but it was actually a tree stump that was clearly on private property, nowhere near the shoreline, and it was actually cut because the county of Maui thought it may be at risk at some point in the future. And sure enough, at the time, later, the ocean and the submerged, it became submerged, sometimes partially, sometimes fully. And one day, a body surfer went out there and hit it and got hurt. And he brought in everybody, and that made me very concerned. And I had to start from that point on, going back to my land division staff and telling them that we're going to have to require an easement. I do recognize this seems so unfair for us to require, but the statute, we have no alternative in the current law and the statute. Any easement we grant you have to pay for it and have to be determined by fair market value by an appraiser. So the board, bringing these kind of cases before the board is pretty much handcuffed, and they want to protect the state for liability and insurance purposes, which the homeowner is more than willing to give. But oftentimes the homeowner have a real problem about having to pay again for property that it already paid for in the past, or its predecessor paid, and it once owned.
Thank you. I'm sorry.
Thank you. Thank you. Representative Kaufman.
Thank you, Chair. A couple related questions. What is the scope of this? Is this a dozen properties or hundreds?
I don't know. We find out a lot about. We don't have the manpower to go to enforce and to check all the shoreline areas. But the most common way or typical way this comes to our attention is the shoreline property owner wants to do some remodeling, goes into the county for a building permit for his home. The county in the building permit process requires a shoreline certification because the county has a setback from the shoreline. During that process, our Office of Conservation and Coastal Lands, our shoreline experts, together with the Land Division and the state surveyor, sends out a team to go inspect the property at that point and to determine where the shoreline is, together with the homeowner's surveyor. At that point, sometimes encroachments are discovered to be structures within the shoreline. The process for shoreline certification stops, and at that point, the team tells the landowner, well, first, Sam and his crew and the shoreline experts will evaluate the structure to determine whether it should be allowed to stay or needs to be removed because it's impacting the shoreline and will have future impacts on the shoreline in a detrimental way. But in instances where they have determined that the structure will not have that effect, that it can stay, it then tells the homeowner, you're going to have to resolve this encroachment with the Land Division and the board by getting an easement granted, and that's where we come in. But otherwise, that's almost always the case how this encroachment comes to our attention. Yeah.
So in the future, with the water levels rising, this is going to become a bigger issue, isn't it?
I think so, and that was one of Office of Planning's concern as well, and why we try to come up with this language on the amendment. Yes.
Thank you.
Thank you, Representative Lowen.
So when fair market value is determined, does it take into account beach erosion or projected sea level rise?
Not for the appraisal. Yeah, not for the appraisal, because the appraisal is just determining what is the fair market value for the encroachment to remain.
So if fair market value took that into account, would it help to address some of the issues that you're facing, and maybe on a broader scale? Does that make sense? Because it seems like if you know that there's beach erosion happening on a property or sea level rise is projected within a certain number of years, then the value of that property or the structure that will be affected should be decreasing.
The appraisals that I've seen that have come in do not address that. The future continued erosion of that property and how does that impact the value. They go on the value as of today. That's just generally accepted appraisal practices. I think what you mentioned though, and maybe if Jesse's here, I think he certainly, him and the coastal zone management crew, and I'm sure Sam and his crew would certainly want to address. Is the Office of Planning here? Yeah.
Madam Chair, committee members, Jesse Suki, Director of Office of Planning. Our office administers the Coastal Zone Management Program, and part of the program under 205A-2, which is the list of criteria that we look at when we evaluate projects in the special management area, includes coastal hazards. And the CZM Act, because it's an act that applies to all decision-making in the coastal zone, even DLNR evaluates that criteria when they go through their process. The language that we agreed to in consultation with DLNR was an attempt to address that concern that we don't want to reward private risk-taking. Sotomura, which is one of the seminal cases about shoreline setbacks, one of the things that the court stated and quoted favorably from another jurisdiction was that when littoral landowners, that's people who choose to live next to the coast, decide to live next to the coast, they're taking on the risk that knowing that the ocean someday can take their property away. So the language we have in there is to ensure that these landowners know that we're not rewarding private risk-taking.
Okay, thanks.
Okay. All right, thank you very much. Thank you, members. I hope everyone indulged me. We had some fishermen came here, and they've been sitting since 8 o'clock this morning. I think they were outside when we got to the fish bill, and I just want them to know that we got only support for the bill. And I'm willing, if you wish to come up and say a few words, we can go back if you want. If not, I just want you to know it was 100% support for it. So up to you. We have a busy agenda. Do you mind? Well, please. You were here since 8 this morning, so I appreciate it.
Sorry, I apologize for that. I planned to sneak something in on my testimony for the next bill, but thanks for the opportunity.
So this is House Bill, again, 989 relating to fish.
Yes. Yes. My name is Matthew Ross. I'm a full-time aquarium fish collector on Oahu. I support this bill. We're actually in the process right now of, through administrative rules, we're strengthening the fishing regulations specific to aquarium fish on Oahu. Those regulations include restricted species, size limits, and bag limits on some species. I support this bill because it will increase the enforcement ability for those measures. Nothing is perfect, but the fact that this bill will raise the available fines means that it acts as a strong deterrent to people who would choose to break the law. As what I consider to be an ethical fisherman, I have no problem, and I don't feel I'm doing anything wrong. I have no problem with supporting a measure like this, and I hope it passes.
Thank you very much. Thank you. Okay. Quickly, please.
Thank you, Chair. Just real fast. I live on the Big Island. I flew over this morning. Sorry, we were not here for the hearing. I've been catching fish in Kona now for this is my 35th year. The whole fishing industry in Kona does not condone any illegal activities, and we definitely support Ms. Evans' bill on this to make sure the fines are substantial. Penalties as far as revoking license should maybe also a little bit more included, but we definitely support the bill on the Big Island. Thank you very much.
Thank you very much. Okay, anyone else? Okay, great. Thank you. Thank you for members. We're going to go to House Bill 666 relating to ocean resources, which deletes the 1 gallon per person per day exception to the prohibition against the removal of sand and other beach or marine deposits, except for materials inadvertently taken, such as those carried away on the body, clothes, toys, recreational equipment, and bags from the shoreline area or seaward of the shoreline. Creates an exemption for public emergencies and traditional cultural practices. Ron Tubbs. Opposition. DLNR.
The DLNR supports the bill.
Thank you. Office of Hawaiian Affairs.
Ohana stands on its testimony of support.
Okay. Matthew Ross. Opposition. Bertha Pasabi. Support. Oh, sorry. Matthew, I'm sorry. Please.
Sorry for that. Nice to see you again, Chair. But I'd like to testify in opposition to this bill, but I hope that I'm not in direct opposition, because I understand there is concern about people removing too much sand. Like I said before, I work in the aquarium fish industry. At present, the commercial taking of sand is already prohibited, so I have no financial stake in this matter. I'm solely testifying out of personal interest. The fact is that keeping aquariums is something that's important to a lot of people in Hawaii. It's a way for people who aren't able to go diving or snorkeling and enter the ocean to experience our marine life. Most people who have saltwater aquariums need to put sand in the base of the tank, and the best substrate for that is local beach sand. In fact, local sand contains microorganisms that help filter the water and are beneficial to the tank. Now, it's not something they need to take a lot of. Personally, I have an aquarium that I've had for 9 years now. I took 1 gallon of sand to fill the bottom, and that's the only sand I've ever taken. I think the impact from activities like that and other small impact personal things that people in Hawaii can benefit from is minimal. I would like to see some sort of compromise between sort of just allowing anyone to take sand whenever they want and allowing people to use what's basically an abundant resource that we have. It might be possible, for instance, for the department to issue like a one day only free license to someone. You could apply for it and just if you have the piece of paper, you can go take a small amount of sand on that day, and that's it. So I'm hoping that there will be some sort of compromise that can be reached. The other problem I have is that reading the bill, it looks like there's no differentiation between rubbish and naturally occurring deposits. So if you interpret it too strictly, it could make it illegal for people to pick up like man-made rubbish off the beach. So at the very least, I think the bill needs to be amended so that only naturally occurring marine deposits are regulated, because there's a lot of like plastic and abandoned fishing nets and bottles and stuff that wash up that really people should be allowed to take those as much as possible. So thank you.
Thank you. Okay, Bertha Pasabi, support. Nicholas Ramirez, support. Pete Pasabi, support. Tetuna Fa'avese, support. Christopher Jury.
Hi everyone. Morning. It's still barely morning, but thank you for listening to my comments today. I'm a graduate student at UH Manoa in the Department of Oceanography, and my doctoral research deals primarily with human impacts on coral reefs. And let me first say that I oppose the bill, but I strongly support what I think is the intent behind the bill, which is to safeguard our marine resources here in Hawaii. And let me detail here very quickly why I don't support this bill. I took the liberty of creating an estimate of the impacts of sand collection for marine aquariums, things like that. In my written testimony, I won't go through the details of that, but let me just hit the highlights of that. Based on the number of people that keep marine aquariums throughout the United States and the number of people we have here in Hawaii, I estimated that on the high end, there are probably about 2,500 people keeping marine aquariums in Hawaii. If all of those people went out 365 days a year and collected a gallon of sand, so the maximum legal limit, they would collect a little over 900,000 gallons of sand per year, which is a big number, but let me put that in perspective very quickly. In a budget for the sand production in Kailua Bay was published a few years ago by researchers at UH Manoa, and obviously Kailua Bay is a small part of Oahu. But that estimate found that Kailua Bay is every year producing more than 1 million gallons of sand. So even if everyone in the state that had an aquarium went out and collected as much sand as they legally could, they would still not be collecting as much sand as just Kailua Bay produces. But as Matt said, no one in their right mind wants 365 gallons of sand per year. You might want a gallon of sand to set up an aquarium or something like that. So realistically, we're probably talking about 2,500 gallons of sand per year, which is 0.23% of the sand produced just in Kailua Bay. Say nothing for the rest of the state. I also estimated how much sand we might accidentally take away from the beach on our bodies, on toys and bags and things of that sort. And for this, I just made a rough estimate of when I get back in the car and drive away from the beach, I've got a little pile of sand. So I figured anytime I go to the beach, I usually end up with at least a teaspoon of sand going back with me. If we figure all the people in the state make it to the beach on average at least once a month, that ends up coming out to almost 15,000 gallons of sand per year, which is almost 6 times the size of the impact of collection for marine aquariums. Either of those is completely trivial. So as Matt suggested, I think there's a way to compromise, perhaps, as he suggested, allowing a 1-day permit to go collect sand so the people that are using it for a legitimate use can go do that and have no real impact on the marine environment. Yeah, thank you for listening.
Thank you. Anyone else wish to testify? Not members, any questions? Oh, yes, please. Okay. Okay.
Real quickly, again, Jim Lovell from the Big Island. Thanks, Chair Evans. You know, on Oahu, obviously, there's quite a bit of sand. On the Big Island, we have a lot of lava rock. And although, you know, the sand is good for aquariums, you know, for startup organisms, I do think that, you know, protecting the resources is critical. So if we can come up with a compromise that, you know, does protect our resources, I think the bill itself is good. I'm in support of it. And hopefully we can come up with something that addresses, if Oahu is producing so much sand, then maybe we can find some way to do something with it. But on the Big Island, I think that this is a good idea. Thank you.
Thank you very much. Okay, members, any questions? No, thank you, members. With that, I'm going to recess the joint hearing.
And with that, I'm going to open up the committee of...
Chair, I'm not on the Ocean Committee, so I'm going to go, and if I could just be called when you're through. Thank you.
Thank you. So we'll be opening up the Committee of Ocean Resources Management and Hawaiian Affairs. And our first bill will be House Bill 251 relating to Native Hawaiians. Establish a dollar fee for certified copies of birth, marriage, divorce, or death certificates when required to verify qualified Native Hawaiian status for the Native Hawaiian role. Requires Department Director of Health to deposit fee into the state's general fund. The first person up is Mr. Conkling, and he's the Center for Hawaiian Sovereignty Studies. He's in opposition. We have Audrey Giebel in opposition, and Lamia Aya Chino in opposition. We have late testimony from Oha.
Aloha Chair, Vice Chair, members of the committee, Sterling Huang, Public Policy Manager for the Office of Hawaiian Affairs. OHA supports HB 251 with an amendment adding our Hawaiian registry as well.
Okay, are there any more testifiers for House Bill 251? Okay, seeing none, members, are there any comments, questions? Okay, seeing none, we'll move on to our next bill. And that is House Bill 1087 relating to the Office of Hawaiian Affairs. Okay, first up is Scott Nagao. Okay, and comments. Then we have Office of Hawaiian Affairs.
Mr. Chairman, all stands on his comments.
All right, thank you. Kiali'i Makiko.
Madam Chair, can I be called last because there's other state officials that might want to weigh in this?
All right.
Is focused on windward areas. Large surf will impact north and west-facing beaches into tonight. Stronger traits and windward showers will return Monday. Chances for significant rainfall and winter weather for the summits will increase the middle of the week. Here's the forecast for Kauai, Oahu, Maui, Molokai, and Lanai. Today, partly sunny. Leeward, isolated showers in the morning. Windward and mountains, scattered showers through the day. Highs 78 to 83. East winds 15 to 20 miles per hour. Tonight, mostly cloudy in the evening then clearing. Windward and mountains, isolated showers in the evening, then scattered showers after midnight. Leeward, isolated showers. Low 68 to 73. East winds 15 to 20 miles per hour. Saturday, partly cloudy. Isolated showers windward. Here's the forecast for the Big Island. Today, mostly sunny. Leeward, haze, isolated showers. Windward, isolated showers in the morning, then scattered showers in the afternoon. Highs 77 to 82. East winds around 15 miles per hour. Tonight, partly cloudy with isolated showers. Leeward, haze. Low 67 to 72. Northeast winds 15 to 20 miles per hour. Saturday, partly cloudy. Leeward, isolated showers during the day. Haze. Windward, scattered showers. Highs 77 to 82. Low 65 to 70. East winds 15 to 20 miles per hour. Sunday, mostly cloudy with scattered showers windward. Partly cloudy leeward with haze and isolated showers. Highs 78 to 83. Low 65 to 70. Variable winds to 15 miles per hour. Monday, partly cloudy. Haze and isolated showers leeward. Scattered showers windward. Highs 77 to 82. Low 66 to 71. Northeast winds around 15 miles per hour. Tuesday, partly cloudy. Leeward, haze, isolated showers at night. Windward, isolated showers during the day, then scattered showers at night. Highs 77 to 82. Low 65 to 70. Northeast winds around 15 miles per hour.
The ultraviolet index for noon February 2nd in Honolulu is 9. This corresponds to a high exposure level.
At 10 a.m., at the Honolulu International Airport, the sky was fair, with a temperature of 77 degrees. The relative humidity was 50%, and the dew point was 57 degrees. The wind was northeast, at 14 miles an hour. The barometric pressure was 30.12 inches, or 1,019.9 millibars, and rising. Elsewhere on the island of Oahu, Kalaaloa was fair, and the temperature was 76. At Kaneohe, it was partly sunny, with a temperature of 74. At Wheeler Field, fair, and 71 degrees. On Kauai, Lihue was partly sunny, and the temperature was 72. At Barking Sands, fair, and 75 degrees. On Molokai, Molokai Airport was fair, with a temperature of 72. Northeast winds were gusting to 33 miles an hour. On Lanai, at Lanai City, the sky was fair, and the temperature was 72. On Maui, at Kapalui, fair, and 75 degrees. At Kapalua, the sky was mostly sunny, and the temperature was 72. At Hana, haze was reported, with a temperature of 75. At the top of Haleakala, the temperature was 41 degrees. Northeast winds at 30 miles an hour. At Kona, it was fair, with a temperature of 81. Here on the 10 a.m. buoy reports. Wind speeds are in knots. Buoy 51101. southeast at 16, 11 feet, 15 seconds. Buoy 51000, east at 16, 15 feet.
This is a test of the emergency alert system sent from Hawaii County Warning Point on February 1st. You should receive a DMO header, 8 seconds of attention tone, this audio message, and the end of message. If you have any questions, please call 935-0031. I repeat, this is only a test. This concludes the test of the emergency alert system.
Waialoa, east at 10, gusting to 22. Kahuku, east at 14, gusting to 22. Bellows, northeast at 16. Kaneohe Marine Base, northeast at 8, gusting to 16. Kapalui, northeast at 7.
You know what it takes to get out there and do that. The Native Hawaiian people, we ask you for that. I don't want to go back into another election if I choose to, having to go up against what I went on against last time, which was 6 and then 11 in the prior ones, where it's a basic free-for-all. And furthermore, I think by not doing anything, you're damaging the image of the Office of Hawaiian Affairs, because when it gets down to the end, we have these candidates now that are, within their right to come out and run for this office, where since there's practically no oversight and whatnot, you have guys coming out, whether it be from a coaching career or various backgrounds coming out, because why? It's a name recognition base. Because why? They keep thumbing the finger back at you guys, going, if you won't take the lead, the law abiding, what it is, then the Office of Hawaiian Affairs can still stand behind their saying by saying comments and making this kind of things. Because why? There's no position taken, thus we keep lingering along in this apathetic state. All I can say to you folks is, you know what it took to get to your seat, the hurdles you did. Give the Hawaiian people that. That's all there is. If there's something wrong with it, I'm sure the judicial branch would be glad to take a look at it. Until then, we're just sitting around twiddling our thumbs, and the Native Hawaiian people are going to just get either dwindle, get more despair, or perhaps even, what they're being pushed to in some senses, perhaps even get, hopefully not, but maybe even get violent on these things. Because why? Justice and the liberty, as we know it in the American way, is not being served here. And it certainly hasn't been since 2000, in particular. So please consider this. 1887, 1087 and 188, please. Thank you.
Thank you. Are there any more testifiers for House Bill 1088? Okay, seeing none. Members, any questions? Okay, seeing none, we'll move on to House Bill 1088. But to make it clear, we had done a legal check on this. It's unconstitutional, so we're going to defer it indefinitely. But if you want to, the testifiers list is Scott Nagao for Office of Elections. He had some comments. Office of Hawaiian Affairs, comments. Okay, and Office of Attorney General, Charlene Aina.
Thank you, Chair, for deferring.
Yes, thank you. Okay, next we'll move on to House Bill 253. And this is relating to education. Establish the Instructional Office of Hawaiian Studies for the purpose of providing instruction to public school students on Hawaiian history, culture, arts, and language. Makes an appropriation for the Instructional Office of Hawaiian Studies. Okay, we have one late testimony from DOE, Catherine Matayoshi. Is any representative here? Just comments. No position. Okay, are there any more testifiers for House Bill 253? Oh, here am I.
Alright, aloha mai ka luna kia komike. Wone o Kalihua crew. I'm the Vice Chair of the Hakau Leo Hawaiian Language Immersion Advisory Council. And I'm going to just provide comments. I'm not going to take a stance yet. One of the things that I would like to do is put out there that the immersion community is included in this bill, but it's not. It's actual. It wasn't consulted. So the advisory council that I'm a part of is 19 or 21 of the schools, teachers, parents, principals, and this is actually legislation that just recently surfaced and without being consulted. So I think the next meeting of our council is February 9th, and so I'm going to bring this up and hopefully have something, some testimony, either yay or nay on this one. But I actually think the discussion of this bill is a positive discussion because there has to be some sort of remedy of how the state deals with Hawaiian issues, Hawaiian culture, and Hawaiian language in the Department of Education. So, mahalo.
Mahalo. Are there any more testifiers for House Bill 253? Seeing none, members, are there any comments or questions? Okay, seeing none, we'll move on to House Bill 499, relating to the University of Hawaii system, authorizes the establishment of a research program on the stewardship of aquaculture and marine protected areas at the Hawaii Institute of Marine Biology, appropriates funding on a matching basis with federal funds effective July 1st, 2013. Okay, we have Ron Weidenbach from Hawaii Aquaculture and Aquaponics Association in support. Clyde Tamura, College of Tropical Ag and Human Resources in support. And Joanne Leon, Hawaii Institute of Marine Biology, University of Hawaii in support. Are there any more testifiers for House Bill 499?
Good morning, Vice Chair Cullen and Chair Hanohano and other members of the committee. My name is Malia Rivera. I'm a faculty member at the Hawaii Institute of Marine Biology, and we thank you for the opportunity to testify in support of HB 499 that provides matching funds for research related to the stewardship of marine protected areas, specifically the northwestern Hawaiian Islands, and aquaculture research. We very much appreciate this bill going forward and strongly support its intent. We have extensive expertise in these fields of research, and these additional funds would allow us to continue and expand upon this important work for the state of Hawaii. However, we'd like to offer suggested amendments, and we'd be pleased to work with the committees on doing that. Specifically, through previous scientific work, we have established biological connections between the northwestern Hawaiian Islands and the main Hawaiian Islands, so we suggest an archipelago-wide approach might be more beneficial. As well as our mission at the Hawaii Institute of Marine Biology is primarily scientific research in marine areas, but we also have a strong mission in education, so we'd like to expand the language to include the flexibility to have a research and education integrated approach to this, to train the next generation of scientists to support the protection of marine resources in Hawaii. I have with me here, this is Dr. Rob Tonin, who is the principal investigator for a large grant from NOAA's Office of National Marine Sanctuaries to do management research and ecosystem-based research in the northwestern Hawaiian Islands. And Dr. Clyde Tamaru here, who is a aquaculture specialist at the University of Hawaii Trop Ag College, as well as an affiliate faculty member at HIMB. And they both have a extensive history of working not only in their disciplines, but with training students to become this next generation of scientists and managers. So they can also answer any technical questions that you might have about those fields. And I believe both of them have a few additional comments.
Thank you. I'm Rob Tonin. I just wanted to add that the way that the federal funding works right now, it's actually easier for us to finance research in the northwestern Hawaiian Islands than it is in the main Hawaiian Islands. And so this would give the opportunity for the state to leverage federal funding to have a much more relevant focus towards research ecosystem-based management and training of local students in the main Hawaiian Islands. And I'll let Clyde speak to local student training.
Just in addition, though, I have additional testimony from Herb Lee from Pacific American Foundation. He couldn't make the deadline, so he passed it to me and said if I could pass it on. So
Okay,
I have the 10 copies.
And they can make copies.
Okay. One of the things I like to emphasize is that by adding the aquaculture component to work that is being done at HRMB, it brings a very applied practical science to something that's kind of looked at as more academia as far as HRMB is concerned. Our group, one of the things I wanted to point out is our focus on local kids entering into marine science as a career opportunity. A good example, I'm a very good example. I got my my master's degree while doing work at HRMB, and at the time you could count the number of graduate students from the local schools in one hand. So how many years now? 20-something years passed, and you can still do that. It hasn't changed very much. So we have very, very good success at my college. I remind you, I'm at the College of Tropical Ag and Human Resources, but I'm also an affiliate faculty at HRMB. We're trying to attract our next generation of scholars from our local sources because I think these are they've lacked or don't see the relevance, I think, many times in marine science. But there's so much that is relevant and so much that can be done. And we're having this become a formalized program at HRMB is one of the key parts, I think, for success, for our success. And again, that's why I support 499.
Okay, thank you. Okay, are there any more testifiers? No, thank you. Yes? You have to make it short, yeah, because we're running out of time.
Okay, I'll be short. Yes, I guess my name is Matthew Ross, testifying in support of the measure, but I'd like to echo the statements that some of the faculty members made. In my experience working in the aquarium fish industry, I found that the biggest improvements in technology and developing new techniques for aquaculture usually come from the bottom up. They come from people like home aquarists or people who are breeding the fish as a hobby. I'm concerned that if this bill goes forward, it emphasizes that there needs to have a strong applied component. Otherwise, simply working on everything from an academic level won't work when you're talking about developing an industry like that. Also, another problem I see in our resource management is that, as one of the faculty mentioned, a lot of funding is directed to the Northwest Hawaiian Islands, where none of us live and work. Unfortunately, there's a lot of I feel that sucks away resources from the main Hawaiian Islands where we do actually have a human impact, and we need to learn to share our resources with each other. I would like to see more funding directed to conserving what we have here rather than what's so far away. Mahalo.
Okay, mahalo. Okay, seeing no more testifiers, committee, are there any questions or any comments? Okay, seeing none, we'll be moving on to House Bill 1446, and this covers relating to the University of Hawaii at Hilo, making an appropriation to the University of Hawaii at Hilo to support Kahaka Ula o Ke'eliokalani College of Hawaiian Language and student support programs at the University of Hawaii at Hilo to support Native Hawaiians and Native Hawaiian programs. Okay, first up is Donald Strani, University of Hawaii at Hilo, in support. Dr. Keiki Kawai'aia in support. Oh.
Aloha. I'm here on behalf of Kahakaula Ke'eliokalani Hawaiian Language College at UH Hilo. I'm a faculty member there. My name is Makalako Lancaster, and would strongly urge support for our continued work, both undergraduate and graduate level programs. We currently have over 200 majors in our college, as well as we do teacher preparation for Hawaiian immersion and Hawaiian culture schools. We have 2 master's programs and a PhD program. We're stretched really, really thin without additional personnel, both at the instructional level as well as student support services that help to recruit, retain, and get our students through in a timely manner. So we urge your support of our continued work.
Mahalo.
Mahalo.
Okay, and then we have Dr. Hiapo Pereira, University of Hawaii at Hilo in support, and Mr. Ekekela Iona, Ahapunana Leo in support. Are there any more testifiers for House Bill 1446? Seeing none, members, are there any questions, comments? Okay, seeing none, we'll move on to our next bill is House Bill 359 relating to ocean resources. Okay, first up is, let's see. We have a whole bunch of testifiers, and a lot of them are all in support, except I think DLNR in opposition. So we have Ulia Kormecki support, Anthony Naki in support, Matthew Ross in support, Marshall Myers in support, DLNR in opposition. So.
Stand on a testimony with comments.
Oh, okay. Comments. Okay, Berta Basabi in support, Pete Basabi in support, Taituna Fa'avesi in support, Ben Kasuga in support, Robert Hajek in opposition. We have Christine Schmidt in support, Chris Bruner in support, Christine Walsh in support, David Tarnas in support, Douglas Perrine in support, Dr. Dale Sharver in support, Dulis Reedon in support, James Kerr, Janice Kerr, Jennifer Smith, they're all in support, Jeffrey Halverson in support, Jerry Connie in support, John Hoover in support, John Noon in support, Judith Perino support, Kara Posada DeVille in support, and the rest is all in support. It's Christina Anderson, Lauren O'Malley, Lauren Scott, Liz Foote, Lauren Newport, Marion Wilkins, Marjorie Ziegler, Marini Herkes, Makale Shafter, Nicholas Ramirez, Paulo, Randy Furley, Rebecca Humbles, Richard Gordon, Rick Gaffney, Susan Kellam, Tamara Pelton, Tina Owens, and Wayne. Then we have some late testimonies, all in support. So we have Doug Herkes, Thomas Carey, C. Cooner, S. Cooner, May Cook, Dwayne Avery, Marjorie Irwin, James Donovan, Arped Horova, Christopher Jury, Rachel Koshibevisky, Nova Lee, Terry McVan, Steve Meyer, Betsy Morrigan, Lucy Olsen, Leilani Rappaport, Sonora Skiles, Alice Dingban, Cynthia Uri, Nancy Zorn, and Zachary Zorn. Okay, are there any more testifiers that have OHA in support? Okay. We have two. Yes.
And support.
In support. Okay. And you were in support.
And support. I'd like to make one statement. The bill as it stands.
Come up.
Sorry. But yeah, I would stand on my testimony in support. I'd like to make one comment. As it stands, the bill applies to West Hawaii.
Yes, it does.
I fish on Oahu, and as a commercial fisherman, I would have no objections if that were applied over here.
That would apply here. Okay. All right. Are there any more testifiers for this House Bill 359? Seeing none, members, are there any questions or concerns?
So you guys provide comments, and in your comment section, in your first page, it goes, the department notes the elimination of the probable cause requirement. This may present constitutional problems, certainly for criminal prosecutions. So, can you explain that, please?
Well, I'm not a law enforcement officer, but speaking with the Enforcement Office Division, they explained to me that the probable cause, if you're going to do a criminal prosecution, there's a probable cause requirement before you can use whatever you get as evidence in a criminal prosecution. So without the probable cause, then you cannot meet that bar of legal standard to include that as evidence in a criminal prosecution. So that question about how does removing the probable cause now still allow the department to pursue criminal prosecutions is in question.
Okay. So, as you read the measure, or the LNR understands the measure, the probable cause area is deleted.
That needs to be reinserted?
We just want to make sure the
So that it's
language,
clear.
yeah, so we can. We want to make sure that it's constitutional as we move this through, because if you have illegal search and seizure, the case will get thrown out of court. So, if it's no sense we have something of this manner if it's not going to hold up in court on the criminal side.
Yes. So if I understand your question correctly, I guess you're asking whether you should remove the probable cause or
No,
keep it in.
I'm saying is as you read it, you guys believe it's not in here, or your law enforcement department, DoCare, is not saying that it's in this, the department. Have you guys read the bill, or have you guys looked it over?
The current language is that in order for us to enforce regulations, we have to have probable cause.
Right.
Okay.
Yeah.
And so one of the provisions in the bill is that you would remove the probable cause provision, as I understand it.
Okay, so do we need to somehow put language in that will provide the probable cause?
Oh, okay. I think I
I'm
understand
asking
the question.
because you guys made a comment about it, and it's very general, where if you guys would have stated, oh, you guys need to put this in, and...
No, we're not saying that you should put it in. We're just saying because it's a new paradigm for us. We don't have that ability currently to not use probable cause. And so if we don't need to meet that bar anymore, then we don't know how we can. We'd have to consult with our attorneys to figure out how we're going to implement this.
But you guys mentioned it, so there is some concern.
There's a question. Previously, this is not the first time the bill has come up in committee. And so previously, there was always that question about the probable cause. And so we just bring it to your attention.
Thank you.
Okay, because...
Great.
Okay, thank you.
Because I'll just... Because you're actually saying that administrative inspections is not clear. So that needs to be defined. It's trying to be defined in the bill. So do you have any language that might clarify it better? And without losing the probable cause, which we know needs to happen if there's something illegal happening. Otherwise, you cannot enforce anything.
The question about what the term administrative inspections means is a question for us as well.
Yeah.
Because we have already inspections. And so how is administrative inspections different from the current authorities that we have? And so understand that administrative inspections is defined and described in the bill, but then its practical application in the field, when is it applicable or not? That's the question that we have.
Well, thank you for the clarification. Okay, members, any more questions? Okay, seeing none, we'll move on to our next bill, which is House Bill 227 relating to affordable housing credits. And this is removes the county's power to issue affordable housing credits to the HHL for the development of vacant lots. Removes restriction that county requirements for affordable housing will not impair the county's obligation to apply the credits in full satisfaction of all county requirements. Okay, on this bill we have J. Furfaro, Kauai County Council. Is he here? In support, we have a Joanne Yukimura. In support, John Friedel. In support, Bob Hall. In opposition, Bobby Hall, okay. Kamuela Cobb Adams. In support, Craig Iha comments. Gary Hooser, support. Late testimony, Director Jovi Masagatani. In opposition.
Chair Hanahano, Chair Evans, we apologize for the late testimony. We had a late evening yesterday. I just want to summarize very quickly. The department is in opposition to this testimony. This affordable housing credits program actually is a very good tool for the department, and we found that it has helped us in terms of making opportunities available that would not have otherwise happened. Particularly in the county of Maui, we've had interest of developers that want to transfer lands into our inventory in exchange for affordable housing credits. That opportunity would never have presented itself had it not been for this program. In addition, we've received funding, and unlike a private sector situation, when we receive funding, those resources actually go back into the county, and it releases funding in our trust fund that would have been spent for infrastructure for other activities. So it recycles more than once in terms of assisting affordable housing on the homelands and other activities that advance the interests of our beneficiaries. So we just wanted to make you aware that this program actually has been, in its initial phases, quite successful for the department. And thank you for the opportunity to testify.
Thank you. Are there any more testifiers for House Bill 227?
Madam Chair, Cum Hopkins of the Hawaiian Homes Commission. As our chair has stated, opposition at the commission level, we haven't really had a chance to talk too much about it, but we're all fairly aware of what opportunities this affords us, and so I would stand in support of our chair and the director of the department in opposition. Thank you.
Thank you. Okay, are there any more testifiers? Okay, seeing none, members, are there any questions? Okay, seeing none, we'll recess for recess from this agenda. And now we're going to be holding a joint hearing with Waterland, and we'll be back on with a joint hearing from Waterland. Okay, House Bill 1352 relating to water exempts owners of Kuleana lands from all state, county, and municipal taxation, fees, and charges of every kind for water usage in connection with the Kuleana landowners' prudent water rights. First up is Frederick Pablo, Department of Taxation. Comments? Namea I.R. Hoshino, opposition. And then we have DLNR, William Isla, in opposition.
Good morning, Madam Chairs, members of the committee. My name is Lenore Owe, testifying on behalf of the Department of Land and Natural Resources and the Commission on Water Resource Management. The Department and the Commission appreciates the intent of this measure. However, we are concerned that the amendment to the Water Code is not the appropriate vehicle to move this legislation forward. Our major concern is that matters related to taxation are more appropriately addressed at the county level if it's regarding property taxes through county ordinances, or if it's regarding general excise or income taxes, that's more exemptions are called out in chapters Title 14, chapters 235 and 237, under the statutes administered by the State Department of Taxation. The state water code does have nothing to do with taxation, and so we don't believe the amendment to the water code is appropriate. The other major concern we have is that we don't know of any statewide inventory of Kuleana lands having appurtenant water rights. There have only been a handful of cases in the courts, and the 2002 legislature clarified for the commission their authority to determine appurtenant water rights. The commission is currently in the process of doing that for the first time in Nawai'eha on Maui. We have 115 claims that are yet to be adjudicated. We don't know what other claims are out there throughout the rest of the state. And so the nexus to the Water Commission appears to be the determination of appurtenant water rights, which we certainly can provide information on as those claims get adjudicated. Finally, there is no fee or of any sort for use of water. In the state water code, water is a public trust, and there is no fees for the commission to determine appurtenant water rights in the code or our administrative rules. We do have a modest permit application fees for other permits that the commission issues. Currently, those are only $25. Thank you for the opportunity to testify.
Thank you. And we have a late testimony from Ms. Pualani Kama'u Dashboss from the Waihe'ema Community Association and Culture Center in support. Okay, are there any more testifiers for House Bill 1352? Okay, seeing none. Right, yeah. Seeing none, we'll be deferring the other joint hearings till next week. Next week, Wednesday. And then because we're going to be decision making for all of the bills that we have just gone through. I know this is a very busy agenda, but we're just going to make sure our triples are out before the deadlines. Okay, so we're going to just resist for decision making and defer the other 5 bills, which is House Bill 1093, House Bill 1424, House Bill 931, House Bill 938, and House Bill 1387. And this will be heard on next week, Wednesday, at 8:30. Okay, so we're on recess for decision making.
radio broadcast segment of the Hawaii State Emergency Alert System. This test message is being broadcast simultaneously over all radio and television stations in coordination with the monthly test of the statewide outdoor siren warning system. During this test, all warning sirens sound a 45-second steady tone. If you hear this tone in circumstances other than a test, tune in to any local radio or television station for emergency information and instructions. Hawaii's broadcasters voluntarily make their facilities available in times of emergency. We are testing the equipment connecting the stations to the emergency alert system. During an emergency, please pay close attention to official radio and TV broadcasts and to instructions from emergency response personnel. Do not tie up vital communications by making non-emergency telephone or cellular calls. If you need emergency assistance, call 911. Emergency preparedness information is found near the front of your telephone directory. We return you now to regular station programming.
Thank you, everybody, for your patience. I'm going to quickly, members, I'm going to go to the 9 o'clock decision-making that we had on House Bill 866 relating to sewer system servicing on Hawaiian homelands. We passed out House Draft 1 amendment for you, so you have it in front of you. So basically what we did is just added some language. Basically, this is about sewer systems that were developed by the counties. It's also about sewer systems that will be built on Hawaiian homelands, and how in the counties, after they normally people build these things, they go to the county and work through the dedication process, and the county takes these facilities over. So this was, I think, important clarifying language. The amendment, I think, makes it much more out in the future. If anybody ever reads this law, I think there's a lot more clarity with the amendments. And we did have the hearing on it last week. So members, do you have any questions? I'm going to recommend we pass out with the House Draft 1. Okay. Vice Chair, take the vote.
Okay, the recommendation is to pass HB 866, House Draft 1. Chair and Vice Chair vote aye. Representative Kaufman? Aye. Representative Cullen? Aye. Representative Hanohano?
Aye.
Representative Kawakami?
Aye.
Representative Lee?
Aye.
Representative Fale?
Aye.
And Representative Thielen?
Aye.
Chair, your recommendation is adopted.
Thank you. We're going to recess the Water Land Committee and then reconvene. We have decision making on joint bills. The first one was House Bill 797 relating to coastal zone management. I conferred with my chair. If you're in agreement, we are going to defer this bill at this time. Yes. And we expect further discussion, and we do have time to schedule it again if we so choose. Members, any questions? Okay. House Bill 1249 relating to Hawaii Community Development Authority. The recommendation, if you concur, Chair, we want to defer it for decision making on February 4th's agenda. I think our hearing starts at 9 o'clock. Yes, I'm going to put 9 a.m.
I do agree.
Thank you. Okay, relating to Makua Valley, House Bill, I got my pen kind of 509 or 809. But anyway, relating to Makua Valley, our recommendation is to defer it, but we expect to bring it back. We need some work with some of the stakeholders and rewrite it, and then we'll schedule it for decision making. Members, any questions? Okay, if not, House Bill 1444 relating to Hawaiian homelands. The recommendation is to defer. And you're in concurrence?
I agree with that.
Okay. House Bill 703 relating to memorials. Our recommendation, Chair, if you concur, is to hold the bill and in the Standing Committee report make mention that the Department of Land and Natural Resources will be working with any concerned parties on this issue. And having said that, take the vote.
The recommendation on HB 703 is to hold, noting all members present. Are there any reservations? And are there any noes? The recommendation is adopted.
Okay, thank you.
And I do agree. Yeah. Aye.
Okay, let's take the vote.
Noting same members in the committee with the exception of Representative Thielen, measures held.
Okay, thank you. Members, I'm sorry, I do have to go back to the House Bill 1249. I'm gonna, I can't have it at 9 on Monday. I have to have it at 11 o'clock on Monday for decision making. Okay, thank you. On House Bill 710 relating to fish ponds, the recommendation is to pass as is. Members, any questions? If not, take the vote.
Members, the Chair's recommendation is to pass HB 710 as is, noting the presence of all members. Are there any reservations?
Yes.
Okay, noting reservations for Representative Thielen. Are there any noes? Chair, your recommendation is adopted.
Chair Hanohano.
Vice Chair, take the vote. We're in agreement, and we take the vote.
Members, same measure, same members, except Representative Thielen. All members vote aye. Chair, the measure is adopted.
Thank you. On House Bill 550 relating to public land, the recommendation is defer the bill for decision making at 11 o'clock on Monday. On House Bill 1268 relating to public lands, the recommendation is to pass as is. Members, any questions? Okay. Not?
The recommendation is to pass HB 1268 as is, noting the presence of all members. Are there any reservations? And are there any noes? The recommendation is adopted.
Thank you.
Committee on Ocean Resource Management and Hawaiian Affairs, same recommendation, pass it as is. Any comments or questions? Okay, seeing none, Vice Chair.
Noting the same members in both committees with the exception of Representative Thielen, all members vote aye. Chair, the measure is adopted.
Okay. House Bill 1292 relating to public land, the recommendation is to pass out as is. Members, any questions? If not, take the vote.
So voting to pass HB 1292 as is, all members present. Are there any reservations? Are there any noes? Chair, your recommendation is adopted.
Okay. For the Committee of Ocean Resource Management and Hawaiian Affairs, same recommendation to pass it out as is. Vice Chair.
Noting that OMH is same members, with the exception of Representative Thielen, all members vote aye. Chair, recommendation is adopted.
Thank you. House Bill 583 relating to government, the recommendation is deferred for decision making till Monday 11 a.m. House Bill 939 relating to enforcement of violations by the Department of Land and Natural Resources, the recommendation is to pass as is. Members, any questions? If not,
The recommendation is to pass House Bill 939 as is, noting the presence of all members of the committee. Are there any reservations? Are there any noes? Chair, your recommendation is adopted.
Okay, for the Committee of Ocean Resource Management and Hawaiian Affairs, same recommendation to pass out as is. Vice Chair.
Chair, noting the same members in previous committee, with the exception of Representative Thielen, all members vote aye. Recommendation is adopted.
thank you. House Bill 415, the recommendation by both of us is to defer. House Bill 989 relating to fish, the recommendation is to pass as is. Members, any questions? Okay, not take the vote.
The recommendation is to pass HB 989 as is, noting the presence of all members. Are there any reservations? Are there any noes? Chair, your recommendation is adopted.
Thank you.
Committee for Ocean Resource Management and Hawaiian Affairs, same recommendation, pass as is. Vice Chair.
Chair, noting the same members in the previous committee, with the exception of Representative Thielen, all members vote aye. Chair, the measure is adopted.
Thank you. House Bill 933 relating to special shoreline encroachment. The recommendation is to pass out with the House Draft 1, defective the date to July 1, 2020, and then make the changes that were recommended by the Office of Planning. There was language changes, I believe it was on section 2. Any question, members? If not, take the vote.
Voting on House Bill 933, recommendation is to pass with amendments. Noting the excused absence of Representative Kaufman, are there any ayes, or are there any reservations?
I'm a reservation.
Are there any noes? Chair, your recommendation is adopted.
Chair.
Okay, going to House Bill 251.
No, 933.
Oh,
933, we're voting on the same.
Oh, 933, same recommendations. Vice Chair.
Noting the previous committee, same members with the excused member being Representative Kaufman and Representative Thielen not on the committee. All other members vote aye. Chair, the measure is adopted.
Thank you.
House Bill 666 relating to ocean resources. The recommendation is defer. And then we're going to adjourn. Do you have the same recommendation?
Same recommendation.
To defer. Thank you. We're going to adjourn the joint committee. And then you have to
Committee of Ocean Resource Management and Hawaiian Affairs for the following bills. House Bill 251, House Draft 1. Recommendations to House Draft 1 using the OHA amendments. Okay, committee members, any questions or any comments? Okay, seeing none, Vice Chair, take the vote.
The recommendation of the chair is pass House Bill 251. Recommendation of the chair is to pass with amendments. Chair votes aye. Vice Chair votes aye. Rep. Kaufman. Excuse. Rep. Evans.
Aye.
Rep. Kawakami.
Aye.
Rep. Lee.
Aye.
Rep. Lowen.
Aye.
Rep. Lally.
Aye.
Chair, the measure is adopted.
Thank you. Next is House Bill 1087. We're going to do a House Draft 1 with the Attorney General's amendments. Okay, are there members any concerns, questions? Okay, seeing none, Vice Chair, take the vote. HD1. Yeah.
Recommendation of the chair is to pass HB 1087 with amendments, noting all members present except Representative Kaufman. Any other members vote reservations. Any members voting no. All other members vote aye. Chair, measures adopted.
Thank you, members. Next is House Bill 1088. We will defer this indefinitely due to when we did the legal check, it's unconstitutional. Okay, next House Bill 253 relating to education. Since there were some discussions on it and nobody was really clear of what they really want, we're going to defer it as of this time. And House Bill 499, we'll be doing a House Draft 1, and we'll be having the people from that marine biology and amend this bill to make it a better bill. So, members, are there any questions or concerns? Okay, seeing none, Vice Chair.
Members voting on House Bill 499. Recommendation of the chair is to pass with amendments, noting excused member Representative Kaufman. Any other members voting with reservations? No. Seeing none, all members vote aye. Chair, measures adopted.
Thank you. Next is House Bill 1446. We're going to pass this out as is. Okay, members, any questions, concerns? Okay, seeing none.
Members voting on House Bill 1446. Recommendation of the chair to pass as is, noting excused member Kaufman. Any members voting no? Any members voting with reservations? Seeing none, chair's measures adopted.
Thank you, members. Next is House Bill 358. We're going to pass it with an HD1 to work on the language on this bill.
You said 358. 358.
Oh, 359, excuse me. I call up my 359 too long, this agenda. Yeah. So, Vice Chair, can you take the vote?
Recommendation of the chair is to pass House Bill 359 with amendments, noting excused member Kaufman. Any members voting with reservations? Any members voting no? Seeing none, all other members vote aye. Chair, measures adopted.
Okay, on House Bill 227, on these housing credits, the County of Kauai has some problems with it. So what we're gonna do is put a the effective date so we can work it out. Effective date would be 7/01/2020, and making sure that the representatives and the senator from Kauai will be able to have a more healthy discussion with DHHL to have a discussion on how they can make things better with the housing credits. So we're going to pass it out with a HD1. And are there any comments?
Sure. Thank you, Chair. And I appreciate the willing to compromise with DHHL. We're going to go back and work with our housing department. Currently, our workforce housing policy allows 25% of the developer's credits to go to DHHL, and the other 75% serves Hawaiian people that have less than 50% and non-Hawaiians, and so everybody gets a piece of the pie. So I look forward to being a conduit to bringing the parties together to go talk story. Okay, thank you.
Thank you. And also, we'll note it in the committee report then how we're going to try to get a better policy for the County of Kauai and that understanding between DHHL and Kauai's county. Okay. Next is House Bill 13. Oh, can we take the vote?
Voted on House Bill 227. Recommendation of the chair is to pass with amendments, noting excused member Kaufman. Any members voting with reservations? Any members voting no? All the members vote aye. Chair, measures adopted.
Thank you, members. And the last measure we have is, and it's a joint we'll recess, okay, from Ocean Resource Management and Hawaiian Affairs. Now we're back on for decision making for House Bill 1352 relating to water. On this measure, because there's unclear, languages, and I think I know we need more discussion, so I would prefer that all the agencies try to get together and work it out so we can get a better handle on this policy with Kuleana Land. So we're going to defer it, and we still have time to come back if we need to when we get a better policy agenda. Okay? So, mahalo ia o kono ko hele mai ana, ano lohi, ano malui lui bako. So thank you all for coming. It's been a long agenda, but mahalo for your indulgence, and ahui ho e malama pono. Thank you. And this concludes the committees for Waterland and Ocean Resource Management and Hawaiian Affairs. Mahalo.